Wow. Oh, so you think slow. Yeah, actually, Grinding away. Mark it with some. How they go. Even this one. The state. Judiciary.
All right, nice meeting you both. Both. Where's the other guy?
Which Ali or Mr. Woman? Yeah, you went on first.
So you get to go out next.
A little time.
Oh, yeah. Yes, oh, I know, yeah. Oh, yeah. Oh, exactly. Yeah,
You know what?
Yep.
Part of the process. Does around the same time. So it's this year starts.
Could be good if they could put out.
Now there, we actually do actually one. It's often just I can do less yesterday. But even at least when it was like pasta.
It's so funny. So I'm gonna say I'm not asking that.
Okay.
It was a great. That was my
Yeah, yeah.
Thank
Welcome back, Judge. As you can see, things get off the rails here when they decide to have a floor vote. We'll do our best to stick with the program and finish this in a proper way. The next up is Senator Cruz of Texas.
Thank you, Mr. Chairman. Judge, good afternoon.
Good afternoon, Senator.
Under Article 3 of the Constitution, federal courts have jurisdiction over only cases and controversies, which means under the Constitution it has to be an actual dispute, that federal courts cannot simply issue advisory opinions on a question they may have a view on. And one component of Article 3 jurisdiction is the requirement of standing, that in order for a plaintiff to have standing to bring a case, that plaintiff, at least generally speaking, must have a real and concrete injury. Is that right?
That is correct.
So, for example, that means that even if I might have a disagreement with some particular policy or some particular law, that I can't bring a case unless I am personally aggrieved by that policy or that law. So, for example, you're in my alma mater, Harvard, is currently being sued for its explicit and, in my view, egregious policy of discriminating against Asian Americans. Even though I think that policy is egregious, I, as an individual plaintiff, could not bring a lawsuit challenging it because I am not Asian American. Is that right?
If you brought a lawsuit, the court would have to evaluate whether you had an actual injury in order to be able to determine whether it had subject matter jurisdiction to hear the suit.
But if I'm not in the class being discriminated against, then I don't have the ability to bring the lawsuit. Is that right?
I think you'd have to have an actual injury. Certainly people, I think, who are in the class could claim that they had an injury for that purpose.
So now you're on the Board of Overseers of Harvard. If you're confirmed, do you intend to recuse from this lawsuit?
That is my plan, Senator.
Okay. We discussed yesterday how the standard for race discrimination was strict scrutiny. The court has laid out a different standard for gender discrimination. What is the constitutional standard that applies to gender discrimination?
Gender discrimination, the court has held intermediate scrutiny applies, which is that the government has to have an important interest, and the tailoring doesn't have to be as narrow.
Right. So yesterday, under questioning from Senator Blackburn, you told her that you couldn't define what a woman is, that you were not a biologist, which I think you're the only Supreme Court nominee in history who's been unable to answer the question, what is a woman? Let me ask you, as a judge, how would you determine if a plaintiff had Article III standing to challenge a gender-based rule, regulation, policy without being able to determine what a woman was?
So, Senator, I know that I'm a woman. I know that Senator Blackburn is a woman, and the woman who I admire most in the world is in the room today, my mother. It sounded as though the question was...
But let me ask, under the modern leftist sensibilities, if I decide right now that I'm a woman, then apparently I'm a woman. Does that mean that I would have Article III standing to challenge a gender-based restriction?
Senator, to the extent that you are asking me about who has the ability to bring lawsuits based on gender, those kinds of issues are working their way through the courts, and I'm not able to comment on them.
Okay, if I can change my gender, if I can be a woman, and then an hour later, if I decide I'm not a woman anymore, I guess I would lose Article III standing. Tell me, does that same principle apply to other protected characteristics? For example, I'm an Hispanic man. Could I decide I was an Asian man? Would I have the ability to be an Asian man and challenge Harvard's discrimination because I made that decision?
Senator, I'm not able to answer your question. You're asking me about hypotheticals and
I'm asking you how you would assess standing if I came in and said, I have decided I identify as an Asian man.
I would assess standing the way I assess other legal issues, which is to listen to the arguments made by the parties, consider the relevant precedents and the constitutional principles involved, and make a determination.
Okay, let's go back to your favorite topic of this hearing, which is the criminal law cases you had as a district judge, and in particular, the cases involving child pornography. Now, your defenders, both on the Democratic side of the dais and also in the press, have suggested that the criticism that has been raised has been somehow cherry-picked, that it's only some specific examples. So I'm going to give you an opportunity to discuss each and every case you've had, because looking at your cases, and I've now examined all of the child porn cases you've had as a federal district judge, there is a very consistent pattern. So let's start, and by the way, I'm excluding the cases. So Senator Durbin and Senator Coons focused on the Nickerson case, the Fife case, the Nguyen case, and the Hilly case. I'm excluding those because those are not child porn cases. Those are actual sexual assault of a child, which is markedly different. And I will concede when you're dealing with sexual assault, you have been willing to impose stricter penalties. So let's focus on actual child pornography cases. And let's go through each of them, because if it's right that we're cherry picking, then you should be able to explain quite powerfully. Now, your justification is that you're following the statute. And as you know, 18 U.S.C. section 3553 lays out the factors that as a district judge you had to consider in sentencing. And let's start with the Hess case, United States versus Hess. Now, in that case, a man sent 6 pictures of a prepubescent girl that he claimed was his daughter to an undercover law enforcement officer. Officers found over 600 images of child pornography, including images of sexual acts being performed on prepubescent children. The defendant pled guilty, and I believe in all of these cases the defendant pled guilty. So there's no question about guilt. They came in and pled guilty in your courtroom. The charge carried a mandatory minimum sentence of 5 years and a mandatory maximum sentence of 20 years. The sentencing guidelines recommended 151 to 188 months sentence. The government, as part of a plea deal, agreed to argue for 60 months, but didn't agree that that would be the sentence, simply that they would advocate it. And you, in turn, sentenced Hess to 60 months. So under the terms of the statute, why did you choose to sentence Hess to the absolute lowest possible sentence you were allowed to sentence under law?
Thank you, Senator. I have spoken at length throughout this hearing about these cases. I've said what I'm going to say, which is I've taken every case seriously. These are
Do you have anything to
very
say about the Hess case?
horrible
I'm asking you specifically
crimes,
about the Hess
and
case.
I've taken every case seriously.
So you're not going to answer that?
These are very horrible crimes, as was that one. And as a mother, having to look at these pictures, having to follow Congress's directive, having to listen to recommendations like the government in that case, which argued for 60 months, I imposed the sentence that I believed was the sentence that was required by law.
So I believe you, and I've read your sentencing hearing in each one of these cases for which we have transcripts, and there's several of which we don't have transcripts. So in each of these cases, you read from the same script. So in each of these cases, you say that the distribution of child pornography is an extremely serious federal crime. And you point out that the crime involves people who are taking pictures and videos of real children while the children are being sexually abused. In Hess, you pointed out that he had hundreds of images of children in sexually compromised position. Some of them engage in sadomasochistic acts. All of this I'm reading from you on the bench. And most importantly, the children in these pictures are not knowing and willing participants in the degrading conduct that was being depicted. They were being forced by someone off screen to commit unspeakable acts of sexual violence for the pleasure of the people filming them and for the gratification of people everywhere. And what concerns me is that many of those people have absolutely no shred of empathy for what that conduct does for the children who were being abused in this way. And you read this script in every one of these cases. So you talk about that these are terrible, terrible crimes. But you also, and in Hess, you said, I have to say that what I found particularly disturbing about your offense was that, quote, you apparently concocted a story about having photographed your own daughter, who you purportedly were willing to take pictures of to trade with other people. I know from your comments and from those who know you that you are unlikely to ever harm a child, which I find remarkable that you've got a child predator in your court who says, I'm unlikely to harm a child. And you say, well, you told me that, so clearly you're unlikely. But you say, but in the context of the crime, you represented that you would. That in and of itself is astonishing. So you talk about it as astonishing. You nonetheless sentenced him to the very lowest possible sentence allowed under law. And what's striking is in these cases, and half of them in 5, you sentenced the defendant to the absolute lowest sentence under law. Let's look at another case. Let's look at United States versus Chazen. Now, Chazen is a particularly nasty case. In Chazen, the defendant was accessed a Dropbox that contained 35 videos and 13 partially downloaded files of prepubescent minor females engaging in sexually explicit conduct. At least 3 of the instances of prepubescent female children were engaged in sexual activity with adult men. The images included the sexual abuse of children, including those as young as toddlers. And several of these cases that you had involved the sexual abuse of toddlers, which is truly horrifying. In this instance, Chazen pleaded guilty. The guidelines recommended a sentence of 78 to 97 months. The prosecution argued that should be what the sentence was. And you sentenced Chazen to just 28 months. Why did you sentence someone who had child pornography of toddlers being sexually abused to 28 months, 64% below what the prosecutors asked for?
Thank you, Senator. You've picked out, I don't know, 7, 8 cases. I've sentenced more than 100 people.
But not to child pornography.
And in
These
every
are your child
case,
porn cases.
in every case, Senator, I look at the evidence. I look at the recommendations of not just the government, because my duty as a judge is to consider all of the arguments that are made in a case. I look at the evidence. I talk to the defendants about the harms that they have engaged in. Many of these defendants are people who.
Okay, Judge, with respect, you're not answering my question. You're right. You talked to them about the harms. Let me read you again from what you said at the bench. You said in this instance with Mr. Chazen, you said among the defendants nationwide who received a below guideline sentence on the basis of a downward variance as opposed to a departure, the average sentences ranged from 84 to 92 months. So that's what you lay out as the average. Our Democratic colleagues say, well, other federal judges sentence below the guidelines. That is true. A number of federal judges do. Our Democratic colleagues have not pointed to a single federal judge in the country who 100% of the time sentences child porn defendants to markedly below what the prosecution has recommended, unless you have a mandatory minimum and no ability to do so. In this case, you say comparable defendants are sentenced to 84 to 92 months. Sentencing guidelines by statute require you to have similarly situated defendants sentenced to similar sentences, but you don't sentence Chazen to 84 to 92 months. You sentenced him to 28 months. Why?
Senator, I've said what I'm going to say about these cases. No one case can stand in for a judge's entire record.
Okay, but I'm discussing
And
every one of the cases. So
I
if you're
understand
not
that.
going to explain it, then I'm
Senator,
gonna-
would you please let her respond?
no, not if she's not going to answer my
Well, if
question.
you're just going to give a speech, then you shouldn't engage in questioning.
you are not taking my time. If you want to filibuster, you're welcome to do so, but do it
I
on your
would
own
at least
time.
give you an opportunity to speak, and you should give her an opportunity to respond.
If she wants to answer the question, I asked her why
Please
she
allow
sentenced-
her to answer the
I
question.
asked her why she sentenced Chazen to 28 months when comparable defendants, in
So
her
let's hear
own
the
words,
answer.
were sentenced to substantially higher, and she said she's not going to answer. Did you? I mean, I would welcome your
I didn't
answer,
hear that.
please.
Senator, I didn't say I'm not going to answer.
Okay, well,
I
then
said
please
my
tell us
answer.
in this case, Chazen, why did you sentence him to just 28 months?
Senator, you're looking at the record. I don't have the record here. What I will say is that in every case, I looked at the recommendations of not only the government, but also the probation office, the defendant, the record, the evidence. I took into account the seriousness of the offense. And
By the way, you know, one of the
ruled.
striking things in Chazen, the prosecutor comes in front of you and says, this is the prosecutor's argument at this point. And the prosecutor says, I understand from my experience before Your Honor's objection, policy objections to the 2G2.2 sentencing guidelines. And he goes on to say, however, in this case in particular, the 4-point specific offense characteristic is justified because it contains sadomasochistic images of infants and toddlers. I'm trying to understand how you see someone that possesses images of infants and toddlers being sexually violated, and you sentence them to 64% below what the prosecutor is asking for. You don't provide a justification other than a generic concern that the guidelines are too high. You don't provide a justification as required by statute. So I'm asking you to take the opportunity to explain to this committee and the American people why in 100% of the cases, you have people with vile crimes, and you have language saying they're vile crimes. But then you sentence them to very, very low sentences. And why do you consistently 100% of the time choose to do that?
Senator, no one case can stand in for a judge's entire sentencing record. I've sentenced more than 100 people. You have 8 or 9 cases in that chart.
Okay, Judge, you said that before. These are the 8 or 9 child porn cases. I will say, to correct the record,
I just say to the judge, there's no point in responding. He's going to interrupt you.
Thank you.
Look, I appreciate the chairman trying to filibuster, and if you don't like your witness's answers, you're welcome to provide your own. She is declining to answer the question, and Chairman Durbin, if you want to join her on the bench, you can. But Chairman Durbin,
My job is to make sure.
Chairman Durbin, I'm not interrupting your questioning,
I'm asking you to give her a chance to answer.
but
You
she's
refuse to do it.
consistently said she's not going to answer. I want to clarify for the record, by the way, the case I was discussing was Cooper and not Chazen. But Chazen is, the case that I was reading from your transcript was Cooper, but Chazen, all right, let's get to Chazen. I pulled the wrong tab. Chazen is equally horrifying. And you say in Chazen, this is something Senator Graham asked you. So the guidelines lay out different enhancements, and you say repeatedly, and this is true in all your cases, you say you disagree with the guidelines, you think they're wrong. And the two guidelines you disagree with is one, there's an enhancement for use of a computer, and you say the world has changed, and now all of these are on a computer. And I understand that. I don't agree with you, but I understand that. That is a understandable thing to say. But the second thing you say over and over again is there's an enhancement for the number of images. And you say repeatedly, for example, in Chazen, you say, whatever the state of the law and technology at the time of the guidelines were first adapted, neither the use of the computer nor the number of images are especially aggravating factors today. Now, I find that bizarre. And you say it in every case. You say the number of images, it's not an aggravating factor, it doesn't matter, and you won't apply the enhancement. Do you really believe that a predator that has hundreds or thousands of images of hundreds or thousands of children being sexually violated has not committed an offense that is more serious than someone that has a single picture of a single child? A single picture of a single child is horrifying, but hundreds of children that have been violated, do you really believe that is not a more serious offense?
Senator, I did not have any cases involving hundreds of thousands of pictures.
No, I said hundreds or thousands. You had cases involving hundreds and you had cases involving thousands. You're right, you didn't have hundreds of thousands.
And I also applied an enhancement, just not to the degree of the guidelines.
You're
So
right. It's a 5-point enhancement under the guidelines. You provide 2.
Yes, so not 0,
Okay,
not
you're right,
the
but-
suggestion
But,
that I
but
did.
are you suggesting the number of images doesn't matter? Because you say it in court over and over again that the number of images doesn't reflect that it's a more serious crime. Do you really believe that?
Senator, as I said to Senator Graham, the court is taking into account a number of circumstances. The commission has done a report about the operation of the guidelines, which enhancements actually reflect different levels of culpability with
So
respect.
let me ask you this, Judge. You've said the purpose of sentencing is to distinguish between crimes that are not as serious from truly egregious crimes. Is that right?
No, Senator.
So what is the purpose of sentencing if it's not to distinguish from less serious crimes from truly egregious crimes?
It is to assign proportional punishment. It is to do justice in cases where you have defendants who are convicted of the same conduct, but have differing levels of culpability.
Well, I will point out that you have a pattern. It doesn't matter how egregious the case is. Senator Hawley talked about the Hawkins case where you had an 18-year-old with pictures of boys as young as 8 being sexually assaulted and raped, and you sentenced him to just 3 months in jail. And I will point out the Stewart case, the last one on this list, because we're running out of time. The Stewart case, you describe that he had over 6,700 images and videos. So that's a lot, 6,700. That's a lot of kids
Time
being
expired,
sexually
Senator.
assaulted. You have taken over a minute of my time, Mr. Chairman.
I'll give you-
So
You've been given extra time. You usually ask for it. You're given it.
okay, I know you want to interrupt. I know you don't
I
like
just
this
want you
line
to
of
play by
question.
the rules.
I know you like to interrupt, but
I
you've
like you
consumed a
play by the
substantial
rules.
question of my time of my questioning, and I'm going to ask my questions, and you can, if you
Senator-
want to testify, you're welcome to.
Senator,
Judge,
you play by the same rules as
in
every other
the
senator.
in the Stewart case, you said from the bench, thus, although this is not necessarily an atypical case, your child pornography possession crime was egregious in the court's view. Okay, so this is a bad one. If you're actually sentencing defendants, you said this was egregious. What did you sentence Stewart for? The guidelines said 97 to 121 months. Prosecutor said 97 months. You said it's egregious. 6,700 images. You come in with 57
Time has
months.
expired.
Why
Senators
did you
used 2
sentence
minutes
him to
over the
just
allotted.
57 months in the Stewart case? Do you want to address that? Because you're claiming it's cherry picking. In fact, you're welcome to explain any of these cases, but let's take the Stewart case.
Senator
Why
Coons,
did you sentence him for half the amount?
you're not recognized, Senator. Senator
If you
Coons,
you don't want her to answer that question?
you wouldn't allow her any.
Mr. Chairman, she may answer the question. I've asked her why she sentenced Stewart.
You've
an
gone over the
egregious-
time, Senator, by 2 minutes.
Why she,
and a half.
because you've interrupted me for 2 minutes, Mr. Chairman. Will you allow her to answer the question, or do you not want the American people to hear why, with someone she described as an
Well, There
egregious,
comes a point, Senator, where you get a little bit.
Chairman Durbin,
Yeah.
will you allow her to answer the question?
You won't allow her to answer.
I will happily allow her to, the question is,
Senator
why
Coons, you may
Thank you,
you
proceed.
sentenced
Chairman.
Stewart, an egregious child pornography possessor,
So,
to
Judge Jackson.
half of the amount
Please, Senator.
requested by the prosecutor?
Please, Senator.
Will you allow her to answer the question, Chairman Durbin?
Senator Coons,
Thank you.
Why are you not allowing her to answer the question? There's
You're
not
over the
another
time
senator
by
here
2.5
that you've not allowed her to answer the question.
you're
I'm
finished.
not asking another question, but allow her to answer the question, Chairman Durbin.
thank you, Chairman.
Why
Durbin.
do you not want the American people to know what happened in the Stewart case or any of these cases? Chairman Durbin, I've never seen the chairman refuse to allow a witness to answer a question. You can bang it as loud as you want.
Well, I can just tell you, at some point, you have to follow the rules.
Okay, will you let her answer the question? You've been interrupting, and
We-
by the way, with Senator Graham, it went 10 minutes over. You've
sure
taken a
did.
big chunk of the time. Will you allow her to answer the question?
You've given her.
Why
no
are you afraid of her?
opportunity to
She's
answer.
welcome to answer it right now. Will you let her?
Senator Coons,
Will you let, so no, you don't want her to answer the question?
Senator Coons.
Will you let her answer
Thank-
the question?
Chairman Durbin,
Apparently, you
Judge
are very afraid of the American people hearing the answer to that question.
we here in the Senate, in this committee today, are in the middle of a policy fight. It's my understanding that across this nation, more than 70% of district court judges who impose sentences in cases such as the ones that have been so vigorously debated here depart downwards from the sentencing guidelines, from the requests of the prosecutors. And as you've explained repeatedly and in detail, that's because a sentencing judge is required to weigh a whole series of factors. How many opinions have you written as a judge, Your Honor?
I've written at least 570 opinions, Senator.
And in how many cases have you imposed sentences as a federal judge?
More than 100 cases.
And across all of those, we've just heard very forcefully assertions made about you and your character and your capabilities and your background, narrowing in on just a few. And I would simply put, for those who are watching and trying to understand what all of this is about, that in an attempt to distract from your broad support, your deep record, your outstanding intellectual and legal credentials, that we are taking what is a policy dispute that should be decided by members of the Senate. If we want to change the sentencing guidelines to make them mandatory rather than advisory, if we want to change the structure within which a federal judge imposes sentences, we could do that. But to demand that you be held accountable for this practice that is nationwide and is years old, I view as an unfair misrepresentation of your record. So if I could, let's go to something that you did as the vice chair of the Sentencing Commission, an important vote that you took in 2014. Because in my view, it shows how fundamentally misguided are the attacks that try to characterize you as someone who at all costs will do what you can to help criminal defendants. Let me just lay out the context for a moment. In 2010, Congress, enacting a policy choice, unanimously passed the Fair Sentencing Act, a bill that reduced the disparity in sentences between crack cocaine and powdered cocaine from 101 to 18 to 1. And the Sentencing Commission unanimously concluded this law meant those currently in prison on crack offenses could seek to shorten their sentences. 4 years later, the commission further concluded that individuals who provided substantial assistance to the government, people who cooperated, who helped out the prosecution, could use this law to shorten their sentence retroactively beyond any break they might have gotten for their cooperation. But you disagreed. In your public remarks at the time, you explained that although given your prior service as a federal public defender, it might seem logical you'd support this direction, you could not do so because you concluded it was manifestly inconsistent with the law and would create unfair disparities between those previously sentenced cooperators and those sentenced today. Essentially, if I understand your view, it was that the sentence of a cooperator shouldn't be understood to be based on the sentencing ranges modified by the Fair Sentencing Act, but was best understood as a fixed discount of the mandatory minimum that a Fair Sentencing Act had not changed. I know this is technical, but I just wanted to make sure I'm characterizing this correctly before reaching a conclusion. Do I understand the context correctly in which you made this decision?
Yes, Senator, perfectly. It was debate among the commission, one of the very few in which we couldn't reach agreement about the retroactive application of the Fair Sentencing Act reduction.
And so just to finish the framing, the Sentencing Commission, which often decides things unanimously, was sharply divided. And here's who was on each side. You voted to deny relief to cooperators, to deny them a pathway towards reducing their prison sentences. And you were joined by two conservatives well known to us, Judge William Pryor and now Judge Dabney Friedrich. And the three of you were outvoted by four commissioners, which included Judge Hinojosa, an individual nominated by President Reagan and described as a hard-nosed, no-nonsense judicial conservative, who was on the other side of the argument from you. So you've got four commissioners, including an outstanding conservative Reagan nominee, and they thought the law could be interpreted to give a break on sentencing. And you were on the other side of that argument. If, as someone has tried to paint you, you simply were determined to give every break you could to criminal defendants, all you had to do was join the majority and this would have passed. But that's not what you did. Help me understand why not.
Thank you, Senator. As you say, this is a sort of technical kind of in the weeds discussion, but the top line is that when I looked at the issues and I looked at the law, it was my opinion that the law did not provide for the further reduction that was being considered.
So across an incredibly broad range of sentences you've had to impose and cases on which you've had to opine, I'm picking this one in part because it's not getting any attention in this confirmation process. But for folks who'd like some insight into how you make decisions and how you explain those decisions, there's a video, it's publicly available, of your April 2014 of the public meeting of the Sentencing Commission where you laid out your position. So I encourage folks to just watch that. And they'll see a jurist who understands that her commitment above all is to determine what the law requires and then follow it. In my view, that's an individual who belongs on the Supreme Court. By the way, your position that the law required that there not be further breaks given in this context ultimately won the day. My colleague from New Jersey made a point of mentioning a relevant case, United States versus Booker, yesterday. I have to say that in this case, it was decided in Coons versus United States with a K, not a C. Look, we all have our judicial record from which we work. But the Supreme Court ruled for exactly the same reasons you did in this argument that was made public. So I just think, Your Honor, this is an example of you looking hard at the law, making a tough decision, ultimately being vindicated in that decision, but taking a position that is not the caricature that's been proffered by some of you. Yesterday, I ran through a number of the letters and statements that debunk some of the attacks that have been levied based on a handful of sentencing decisions. There was the National Review piece by a conservative former prosecutor who calls out the smear on your sentencing practices in cases involving child pornography. The statement by the Fraternal Order of Police and the International Association of Chiefs of Police endorsing your even-handed and judicious approach to the law. The glowing letter from 24 prominent conservative attorneys and the resounding recommendation we heard in person from Judge Griffith. There's also been received here a letter from a number of retired federal judges, including two Republican nominees, rejecting this mischaracterization of your sentencing record. As I've said, this is a policy dispute that we should be deciding, not an appropriate basis on which to mischaracterize your record or your character. We have letters from the National Coalition of Domestic Violence in addition to these law enforcement leaders, from survivors, advocates, crime victims. The breadth of your support from the very communities my colleagues have suggested you're making less safe shows just how off base these attacks are. And in my view, is a testament to your qualities and qualifications. So we all agree, all of us, that it's critical to protect our children and prevent the kinds of heinous crimes we've heard about in some detail earlier today. It's why I'm introducing a bipartisan reauthorization of Child Abuse Act, something that we could act on as a committee to do our job, which is set policy and pass laws. But I also frankly think we need to be mindful that we are asking of you to get engaged in that policy dispute in front of this committee, which is not the role of a judge, something you well understand. Let me turn, if I could, to another reason I think you're deeply qualified and that you will bring something important to the Supreme Court. Brian Stevens, one of America's leading civil rights lawyers, and by happy coincidence, a Delaware native, has spoken about how achieving justice requires being proximate to the people most impacted by the criminal justice system, and you've done that. As a public defender, you've represented individuals in the criminal justice system. As a district court judge, you have looked individuals in the eye and told them that for their crimes against society, they will spend years or decades in prison. You have met with, fought for, and advocated for victims. You've also studied the big picture. As an effective and engaged member of the Sentencing Commission, you've pored over data, reviewed thousands of letters, and thought hard about the appropriate national approach to just punishment in a more policy-oriented role. You've also thought about the big picture as a judge when considering the precedent that your opinions set. I'd be interested briefly in how your experience on the Sentencing Commission shaped your approach as a district court judge and how the interplay of all these factors might shape or contribute to your decisions as a Supreme Court justice.
Thank you, Senator. One of the things district judges, sentencing judges often say when asked about the task is that sentencing is the hardest thing that a judge has to do. And it's in part for the reasons that you have articulated, that it's one thing to understand the law, to read it in a book. It's one thing to look at data and numbers and make policy based on that. It's quite another to have someone in the courtroom, whether as a victim of crime or a defendant who's perpetrated a crime, and have to decide how to proceed and pronounce a sentence on that individual. The work that I did on the Sentencing Commission, which was prior to my becoming a district judge, I think enabled me to understand unwarranted sentencing disparity, to understand some of the policy reasons behind the guidelines, and to make the kinds of evaluations that the law now requires since the guidelines are no longer mandatory. And I felt better in a sense about the task of calculating the guidelines, which is what courts have to do at the beginning of a sentence. They can be a little complex, and having been on the Sentencing Commission, I think that helped. And some of these cases do make their way to the Supreme Court. So I think that I am prepared to handle the cases that involve sentencing that do go to the court.
In preparing for this confirmation, I went back and read a lecture you gave, but it was later published in the Harvard Law Review about the balance, the challenge of sentencing, about that moment. I had the joy, the blessing of clerking for a judge on the Third Circuit. My legal skills and talents did not allow me the opportunity to clerk for the Supreme Court as you did, and also the district court and also the circuit court. But I clerked for a judge who I first met when she was a district court judge and imposing a sentence on someone who was a crack dealer. And she did a remarkable job of speaking to the victims, speaking to the community, speaking to the prosecutor and the defense attorney, and then speaking directly to the defendant in imposing a very long sentence. And as I got to know her later, I recognized that, as a member of our community and as someone who saw the importance of that moment, that public moment, of helping the defendant understand what they'd done so that they might somehow change, but also helping the victims understand what had happened, that she took that very seriously, incredibly seriously. In the Harvard Law Review publication of your remarks, you said that you're persuaded by the theories of punishment that accept all human beings are responsible moral agents, and you view punishment as a necessary consequence of the defendant's decision to engage in criminal behavior. You also went on to say that the challenge is balancing the acknowledgement all of us are more than just the worst thing we've ever done, but there is a need to ensure the defendant is adequately addressed and punished. What I think you say in that lecture, what you've shown across the arc of your public service, reveals someone who understands the appropriate need for punishment in our society, but who is also striving to follow the balance of recommendations, guidelines, statute, and the context and facts. And I trust that as members of this committee and the Senate as a whole and the general public take the time, which they should do, to give a fair reading to the whole scope and arc and reach of your service, that they'll see you as someone who cares deeply about our Constitution and the rights that make us free, as you said in your opening statement. Your career in the law, your service on the bench, your thoughtful responses to questions put to you, the way you've maintained your composure, all impress me. As I mentioned, I don't think labels such as a judicial philosophy are always that meaningful or dispositive. I think in your case, a deep admiration for the Constitution and an understanding that the role of a judge is a limited one are critical and qualifying. You opened yesterday by referencing how your parents were educated in racially segregated schools in Florida, but how you, just one generation later, were raised in integrated schools and had far greater opportunities to put your evident God-given talents to work in service to our nation. You cited this one generation change as an example of the greatness of America. Of course, the Supreme Court played a central role in more correctly interpreting the Constitution and applying it in a manner that allowed this reversal of unjust law to occur. I think the experiences of your own family and your connection to the experiences of trailblazers who came before you, on whose shoulders you stand, has meaningfully shaped what kind of a justice you will be. I think you know in your bones how important our Constitution and the rule of law is. And I think as someone who served on the Sentencing Commission, a public defender, on the trial court and appellate court judge, you have the ability to see across the whole scope and reach of how the law impacts families, communities, and our nation. Last, in some ways, I think most importantly, I've learned that as a person and a judge, you have humility. Judge Griffith, who came before this committee to introduce you, and scores of others we've heard from, I've just referenced, have lauded your practice of judicial restraint. And you've said a core component of your philosophy is your understanding that the judge's role is a limited one. Well, I think restraint is a core part of your approach to decision-making, partly because you are a judge who is humble enough to know that the Constitution and the laws passed by Congress say what the law is. The judge has a limited role in deciding questions of law based on facts presented. Penn Law Professor Lisa Fairfax, your other introducer, your dear friend, explained that since college at Harvard and then through law school, you've been a mentor and a role model. She praised your warmth and intelligence, your devotion to friends and family, but she also mentioned your humility. She knew you were honored and humbled by the significance of this moment, not what it means for you, but what it means for our nation. I remember thinking about this on Monday, and I had a chance to talk to your brother Ketanji, and he mentioned that he knew you were destined for this moment your whole life. I am sure he would say you've been exceptional since you were student body president at Palmetto High School. I suspect your wonderful family upbringing is partly responsible for this facet of your character. I suspect your faith has played a role in sustaining you, as mine does, and so does many others in this room. I've often found instruction and comfort in the verse, "What does the Lord require of you but to do justice, love mercy, and walk humbly with your God?" Now, I'm not going to ask you to reflect on that verse, Your Honor, but I wouldn't be surprised if it's one of your favorites that sustains you. Let me close by returning to what Judge Griffith said when he told us in his heartfelt introduction of you on Monday, and something you've also shown in the hours you've been grilled by this body. He'd already written a letter to this committee delivering his endorsement. He took the extra step to then amplify it in person. And he did so because of confidence in you and because he was delivering a message to us as a committee that Supreme Court confirmations should be more than just exercises in partisan tribalism. He said there should be nothing unusual about a judge who just happened to be appointed by a Republican president and who holds conservative legal views coming forward to support a nominee with your impeccable qualifications and character, especially a nominee whose legal opinions, whose actions and decisions as a judge, he was in a position to review for years, given that you were a district court judge and he was a circuit court judge. Look, our confirmation hearings for justices have sadly been devolving over many years into longer and longer exercises of partisan politics, punctuated by just brief glimpses and occasional thoughtful examinations of a nominee's judicial decision-making and views on the Constitution, which should properly be our main focus. I have to believe this sad state of affairs troubles my colleagues of both sides and all who watch this. But as I reflect on these hearings, I'm hopeful that your gracious, thoughtful exchanges with some members will be remembered as just one more service you've rendered to our nation. And I hope some watching these hearings will be reminded that even though we disagree with the policy preferences or opinions of a nominee, we should all recognize when a nominee is fundamentally qualified, deeply committed to the Constitution, rule of law, and a person of great character. Judge Griffith reminded us at the outset of this week, and I quote, "As Justice Scalia taught us for so long, an indispensable feature of the republic the Constitution created is an independent judiciary of judges who've taken an oath not to a president or party, but to the American people and to God that they will be impartial." I couldn't agree more with Judge Griffith. You've demonstrated your unwavering commitment to that oath and your impartiality, your abundant qualifications. It'll be my honor to support your confirmation for Associate Justice. With that, Mr. Chair, I yield.
Thank you, Senator Coons. The senator from Nebraska, Senator Sass.
Thanks, Chairman Durbin. Judge, welcome back. I'd like to associate myself with parts of what Chris said there in his closing. I would differ with him about whether or not getting to precision on judicial philosophy matters, but you know that. You and I have been wrestling about it for a couple of weeks. But I'd like to affirm Chris's point about the beauty of the hymn to America you told, and through the eyes of your parents and the changes, the growth in the country over the course of the last 2 generations. And the Wall Street Journal had an editorial this morning that said pretty much the same thing as Chris just said, which is that the hymn to America that you gave in your opening on Monday afternoon and some of your comments yesterday were inspiring and beautiful. So I associate myself with Senator Coons on that. I'd like to talk a little bit about your time as a judge and particularly how you see development and growth and change over that time. So take us back 9 years and then maybe 5 years ago and then today. How has your approach to being a judge changed from year 1 to year 5 to today?
Thank you, Senator. I do think there was a little bit of growth. I hope there was a little bit of growth. Certainly in year 1 and year 5, I was still a district judge, and both of those years differed dramatically from my work as an appellate judge, which is where I'm currently stationed. In every job in year 1, you're new, you're trying to figure things out. I don't know that I had quite pinned down at the very beginning exactly how I would approach cases, but by the time I got to year 5, I think I had a really good sense of this judging thing and was able to demonstrate in my opinions, the many, many opinions that I've written, the way in which I go about making my decisions. I was able to demonstrate clearly, I think, that the particular parties in the case, the issues in the case, what it's about from a standpoint of personal preference is not an issue. I'm setting those things aside. I am ruling from a position of neutrality and trying to determine in every case what the law requires. I am looking at only the facts and the law in the case. I'm evaluating the arguments of the parties, and If it's statutory interpretation, I'm trying to ascertain what Congress has intended. I am committed, I think my record shows, to the understanding that that is the role and the only appropriate role for a judge.
I'd like to talk a little bit about the troubling pattern we see on law school campuses and across higher education more broadly, especially in the last 5 years. There's obviously a trend toward shouting down and canceling opinions that are outside the left-leaning mainstream. Calls for firing professors, canceling professors, shouting down and sometimes threatening speakers who bring diverse opinions, calls to discipline fellow students. These tactics are increasingly commonplace, particularly against conservative speakers and professors and students, but also increasingly against traditional liberals. I'm a former college president, and one of the sort of oddities that doesn't fit inside the tribalism of how a lot of times media covers things in DC. One of the oddities for me is how often I have liberal professors reaching out to me saying that their experience on campus is becoming much less interesting, that the divide on American political campuses is less and less conservative policy leaning versus liberal or progressive policy leaning, but more and more liberal versus illiberal. And I think these campaigns are obviously deeply problematic. They shut down debate rather than teaching students how to engage ideas that they might not have encountered before, which is also a pretty decent definition of education. If you already knew everything before you ever encountered a new idea, you wouldn't need to write checks or take time off of productive life. So there's obviously a tendency in response for students to self-censor rather than learn from each other, and this robs students of the chance to engage with ideas from across the political spectrum, but in particular, in law schools, it robs students of the opportunity to learn how to consider an alternate position and argue a different point of view than they might have had. So given that you're a debate champion in earlier days as well, I'd like to ask if you agree that law students should be engaging with ideas from across the political spectrum, even those they disagree with, rather than trying to shun those different ideas.
Thank you, Senator. Let me just say, in part because these issues are things that could implicate matters that come before the courts, I will just say that as a general matter, law school, like many schools, is a place where ideas and perspectives are considered. And in the law, as I've said, it's important for the judge who's making the decision to have different arguments. And so one of the things that traditionally happens in law schools is that you are trained in law to make arguments that are at times not even the arguments that you personally agree with, because the understanding is that in litigation, in disputes that come before the court is going to want to hear from different viewpoints. So in that sense, the essence of legal instruction is to have different arguments being made, because that models in great part what happens in a courtroom.
I really am not trying to ask any kind of gotcha question here. I
Yes.
suspect we highly agree, so I don't understand the qualification you put at the beginning. There's no sort of second order fork on my question. It is better to debate ideas that you disagree with than shout them down, isn't it?
It is better in law schools to make sure that there are ideas from all perspectives, and in order to have that happen, they can't be suppressed.
So you don't want students shouting down other students or visiting professors, right? I mean, I'm honestly, I didn't think there was any chance we would differ on this, so I'm not.
Yes, no, I'm not.
Okay.
I'm not suggesting
You're
that we do
against
differ.
canceling people, I assume.
I'm not suggesting that we differ. What I'm saying is that these issues about speech on campus and the like are the kinds of things that are issues that are working their way, in different formats and different ways through the courts. And so I'm just being careful in terms of
Gotcha.
my my answers.
Okay, I'm trying to lead you because I want to, because I think American civic health will be better off. You're going to be a hero. You are already a hero to lots and lots of kids, students, maybe some bound for the law, but more broadly, students across the country. And I think it's in America's public interest for them to hear you as an advocate for the full, vigorous, strong kid debate of different views. And so I suspect you are an advocate for vigorous and robust debate. I don't see how you might be constrained against saying that because of future cases, but I'm going to just assume we're mostly aligned on this.
I think that's a fair assumption.
Thank you. I do want to make, before I move on, just because we've had a number of members of this committee comment on cameras in the court. I've made my position on this clear a lot of times, but if I can give a tiny bit of friend of the court brief in advance, because I think when you're on the court and you all continue to debate this issue, I think it should be a decision for the Supreme Court to make about whether or not there are cameras in the courtroom, not a decision for the Article 1 branch to make for Article 3. But I think it's incredibly important for us to recognize, because I think I differ from a lot of my colleagues on this who are advocates for cameras in the courtroom. I get their position that transparency is a virtue. Transparency is a good thing. I also believe that pen and pad can facilitate a whole heck of a lot of transparency just fine. And it's healthy for Americans to recognize the second and third and fourth order effects of cameras. A huge part of why this institution doesn't work well is because we have cameras everywhere. Cameras change human behavior. We know this. You don't have the same kinds of conversation over the dinner table with your family when you're wrestling through issues and apologizing for something and saying, I said this before, but maybe I should modify what I said. My tone was jerky. My substance didn't account for your position. There's a whole bunch of things that humans can do if they're not immediately mindful of some distant camera audience that they might be trying to create a soundbite for. And Instagram can be useful for some small things, but for intellectual discourse, it is not a friend. And I think we should recognize that the jackassery we often see around here is partly because of people mugging for short-term camera opportunities. And it is definitely a second and third and fourth order effect that the court should think through before it has advocates in there who are not only trying to persuade you 9 justices, but also trying to get on cable that night or create a viral video. So for what it's worth, I hope that the court doesn't respond to some well-meaning impulses from the Congress to push for cameras in the courtroom, but also some bullying. And there are ways that you can get to a lot of transparency. Audio recordings are increasingly released from the Supreme Court in timelier fashion over the past few decades. So for what it's worth, I'm glad that you on the court are making that decision, and I hope it isn't made for you by the Congress. I want to go back to the legitimacy of the Supreme Court. That term has been used a few times over the last 3 days. Do you think the Supreme Court is legitimate?
I do, Senator.
And so some of the ways that the court has been derided and called illegitimate by members of the Senate include, over the course of recent days and weeks, quote, leans into extreme partisanship, leans into extremism, twists the law, threatens basic liberties, has been hijacked by Republicans. These kinds of attacks undermine the public's trust in the court. We need the public to believe in the legitimacy of its government, including all 3 branches. So I would ask you, do you agree with these characterizations of the court that have been levied in this room over the last few days?
Senator, I have nothing but respect for my former judicial colleagues, my current judicial colleagues, and hopefully my future judicial colleagues. I do believe that we need legitimacy. I've said that that's the currency of the court, and I look forward, if I'm confirmed, to joining the institution.
So do you think there could be any opinion that would be handed down this term that could undermine the legitimacy of the court?
Senator, I think the Supreme Court makes its determinations, and all of them are precedents, and they are entitled to respect.
I'd like to come back to our conversation from yesterday. You pointed out a number of times that as both a district and now a circuit court judge, you were constrained and bound by the Supreme Court's holdings. You mentioned a couple of times that you haven't had a chance to do much constitutional interpretation for yourself. I largely agree with the way you framed most of that for the lower courts, but I think you would also agree with me that the job of the Supreme Court justice is different than a district court judge, and in certain ways from a circuit judge as well. When you serve on the Supreme Court, you'll have to interpret what the Constitution means, and based on what you told us about the constrained role on the lower courts, lower court decisions would then not be able to answer how you would approach the new job you would have on that highest court. And so that's why I thought our conversation on judicial philosophy yesterday was somewhat helpful. I'm not a lawyer, but I think you took a lot of us to law school yesterday in ways that were helpful. And in particular, you walked us through some different schools of constitutional and statutory interpretation in ways that I think were good for the committee, were good for the court, and were good for the public more broadly. So I guess I would ask you, if you could take us to law school one more time and walk us through some of the different approaches to substantive due process and unenumerated rights. What are the different ideas on the Supreme Court and in the broader legal community?
Thank you, Senator. I am not mostly familiar with the Supreme Court's precedents in this area. It's been a while now that the Supreme Court has determined that the 14th Amendment, which guarantees due process, includes a substantive component in addition to procedure. The term due process, one would think, is just about the procedures that the government has to afford you before it affects your life, liberty, or property. But the Supreme Court has also said that that protection extends to certain personal, individual rights that relate to dignity and autonomy, and that are deeply rooted in our nation's history and traditions, or implicit in the concept of ordered liberty. And the kinds of things the court has recognized pursuant to that line of jurisprudence are things like marriage, interracial marriage, the access to contraception, a woman's right to terminate her pregnancy, abortion, pursuant to or subject to the framework established in Roe and Casey, travel, the child rearing, the ability to direct your children. Those are some of the rights that have been recognized pursuant to the 14th Amendment due process clause. I'm less familiar with the sort of scholarly debate outside of the Supreme Court's rulings.
So will there be new ones in the future?
Senator, I am not able to forecast. In every case, the Supreme Court is looking at a particular set of circumstances consistent with the Article 3 requirement that the court look only at cases and controversies. So it would depend on what cases came before the court.
So I think that gets at the challenge here that you and I have been going back and forth on over the course of a couple of weeks, because I get the modesty points about being on the district court, but it seems pretty important to understand what the limits might be as a justice. And so I think this morning, again, you stated that I think the quote was that your judicial philosophy is your methodology. But I think that a judicial philosophy of some kind is necessarily an input into your judicial methodology and into every justice's actual jurisprudence on the court. And that's why I think it's important for us to unpack that, because the philosophies that you've outlined for the committee, again, I think yesterday's back and forth that you and I had on Breyer v. Scalia is important, and you wouldn't claim any of those philosophies for yourself And yet I think the philosophies ultimately instruct judges on the sources and the tools they consult, on how they discern intent, on whether the Constitution is protecting specific limited and defined principles or more general values, and whether modern values can be used to infuse our understanding of the Constitution. So again, when you narrated a bit of the debate between Justice Breyer, I know you've got lots of intellectual inputs in life, but you've credited him as a brilliant jurist and role model before. And the Scalia debates, you didn't really tell us who you thought got the better of the argument. And so I think throughout these 2 days, you've focused a lot on what the Supreme Court has said. And I think that is helpful and important. But I've been also trying to get at what you think the limits might be on what Justice Jackson would be constrained by. So I feel like, I believe we still haven't heard your judicial philosophy. And I wish I'd made more progress with you on that. But what we do know on a personal note is that these committee 3 days have been very long. And I want to thank you, and got to have a nice conversation with your parents earlier, your whole family, for what you've endured and for spending time with us. And obviously wish best wishes to you and your family. Thank you, Judge.
Thank you.
One more minute.
Thank you, Senator Sass, and Senator Blumenthal is next.
Thanks, Mr. Chairman. Good afternoon,
Good afternoon.
Judge Jackson. I know your birthday, September 14th.
Yes, sir.
You have the happy coincidence of a birthday with Constance Baker Motley,
Yes, sir.
who just happens to have been born in New Haven, Connecticut.
Ah,
And we're very proud that she is a daughter of New Haven and Connecticut. And she is one of my heroes as well. As you know about her, she was the first Black woman appointed to the federal bench. She is the first Black woman to have argued before the United States Supreme Court. In fact, her record before the court was 10 wins and 0 losses. She was very predominantly responsible for Brown versus Board of Education. Thurgood Marshall got most of the credit, but she did a lot of the work. Probably sounds familiar to you. So why don't you tell us, and maybe tell those folks, particularly women and girls who are watching or listening, why you said at the outset of the hearings here that she was one of those whose shoulders you stood upon as you came here today.
thank you, Senator. Well, in addition to the fact that we share a birthday, which I discovered when I was in law school and thought, what a happy coincidence in terms of someone who I so admired. And secretly at that point, I was thinking maybe I might want to be a judge. So it was a wonderful, wonderful coincidence. I so admired the fact that she was the first. It's not necessarily easy to be the first, but it is an opportunity to show other people what is possible. When you're the first, it means no one has ever done it before like you. And there may be hundreds, thousands of people who might have wanted that opportunity and thought, I can't do that because there's no one there like me. And so being a trailblazer, whether it's Judge Motley or Justice Marshall or Justice O'Connor, being a trailblazer is really inspiring, I think. And I was always moved by Judge Motley's experience, and think it may even be part of why I moved in this direction.
Well, it is inspiring. And I hope that your very inspiring story will make it possible for a lot of others to think it not secretly, but say it out loud and aspire to it, because it's what this country needs. And fortunately, President Biden has recognized it in the nominees that he's put before us. And we've tried to work with the great leadership of Senator Durbin to confirm people of real merit, the kind of qualifications in intellect and character and depth and warmth that you bring to us today. I want to talk a little bit about voting rights, because part of the reason why those dreams now are realities is that more people have the right to vote, at least until recently. In fact, there has been a lot of sliding about turning back the clock on voting rights. The gentleman sitting behind you, Doug Jones, our former colleague, whom we very much respect and admire, wrote a tribute to Vivian Malone Jones, who has a rich story as a civil rights warrior and who succeeded John Lewis as head of the Voter Rights Project. And he said in a speech that Doug Jones wrote in tribute to her as she was inducted posthumously into the Alabama Women's Hall of Fame, I'm quoting, "We can best honor her by acknowledging that while most doors are unlocked today, they are still heavy and so hard to open for so many people in Alabama and the rest of the nation. Let us commit ourselves to do our part to open these doors as wide as possible so that everyone can take the walk that Vivian took." I'm going to ask that former Senator Jones' full speech be entered in the record, Mr. Chairman. Thank you. The simple fact of the matter is, Judge Jackson, Congress passed the Voting Rights Act in 1965. It was a source of real power to so many people who got the right to vote for the first time in practical terms, because it struck down more than 1,000 discriminatory election rules proposed by state and local officials. It opened the ballot box to millions and millions of Americans. And it became regarded as the crown jewel of the civil rights movement. And then, just in the last few years, the Supreme Court has hacked away at it in an exercise of judicial activism that has been historic in magnitude. Judges supplanting their views for the policy preferences and official acts of legislatures in opinions that were written and joined by only conservative justices. These decisions were about as far from judicial restraint as they could possibly be, not even close. And they rewrote the rules of our most cherished and most bipartisan civil rights laws. You know the cases, Shelby County, Brnovich versus the Democratic National Committee. In effect, their opinions, including Justice Alito's decision in Brnovich, are completely untethered from the clear statutory text, and they impose a series of so-called guideposts on Section 2 that create unreasonably high hurdles to the exercise of the Voting Rights Act. I hope that you will bring to the court that deliberate, careful methodology that you described earlier very convincingly. It is part of your judicial philosophy in the sense that it's your approach to cases. And it has been very persuasively and clearly articulated. And I think if that kind of deliberate and careful methodology had prevailed on the United States Supreme Court, we would still have the Voting Rights Act in full right now. And I hope that we can once again return to bipartisan support of those rights. The most recent exercise of unfortunate decision-making in the voting rights area came just hours ago when the Supreme Court struck down the decision of the Wisconsin State Supreme Court in Wisconsin Legislature versus Wisconsin Elections Commission. What is striking is not only the result, but the fact that it was done as part of the shadow docket. We've talked a lot about it here, and what the people of America should know is there's no oral argument. There's only minimal briefing. There are no full opinions of the court. In fact, I'm holding up a per curiam opinion that is about 12 pages in length from the court, which means you don't know who wrote it. And there is a powerful dissent. I recommend that everyone read it. Again, use of the shadow docket has become increasingly prevalent since 2017. And in effect, the United States Supreme Court is shirking its duty. I hope you will bring to the court the kind of responsible and methodical approach to decision-making that will lead to an avoidance of the shadow docket, as well as a return to the Voting Rights Act. And if I can just offer one more piece of advice on the court's workload, I have a chart. I know we're not going by the rules of evidence here, but this chart indicates the signed decisions of the United States Supreme Court over a good part of its history. And I think the pattern here is pretty clear. The court issues fewer signed opinions. In fact, it has declined precipitously since 1972. This little blip at the end here is an increase from 53 to 57, but you can see it's only a fraction of what the court used to do in signed opinions. Even from the time when I was a law clerk, it's diminished profoundly. The Supreme Court needs to do its job. It needs to issue signed opinions, not the shadow docket. It needs to take cases and resolve real, fundamental, important issues. And taking your record, 573 opinions over 9 years. I'm not a math major, but that's about 64 opinions a year. That's a lot more than they do, all 9 of them. So I hope you will bring the energy that you have demonstrated in this room, the energy and the work ethic to the United States Supreme Court, because clearly you have both. And I think the court is very much in need of it, as it is some of the other great qualities, intellect, character, that you have demonstrated here. Just a couple more points, if I may. You were asked earlier about dissents. I want to ask you about one in particular, the dissent of your mentor and your predecessor on the court, Justice Breyer. I am told, I think I've read, that there is one opinion that he is proudest of. Could you tell us what you recall it being, if you know?
Senator, I'm not able to answer that question.
Well, I think he said that The dissent that he is proudest of was in parents involved in community schools versus Seattle School District. I think he said it was the opinion that he was proudest of. And he cited it in a Harvard Law School symposium about his notable opinions. And he said this dissent was most notable. I will give you the citation when we're done, and ask that it be entered into the record, Mr. Chairman.
Without objection.
It's 77 pages long, and it's a dissent. It's a dissent in the parents involved case, which was a 5-justice plurality invalidating public school integration plans in Seattle and Louisville. The plans had been in place for decades, put in place by 2 local school boards, voluntarily trying to address school segregation in public schools in both of those cities. And the justices, conservative justices, striking down the school integration plans said in effect they couldn't move forward with those integration plans. You may recall it is the opinion where Chief Justice Roberts said, very famously, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Justice Breyer, in dissent, which reminded me of a lot of what you've said here this week, wrote, quote, "I do not claim to know how best to stop harmful discrimination, how best to create a society that includes all Americans, how best to overcome our serious problems of increasing de facto segregation. But as a judge, I do know that the Constitution does not authorize judges to dictate solutions to these problems. Rather, the Constitution creates a democratic political system through which the people themselves, through their legislators, must together find answers. The court should leave them to their work." I think that's the philosophy that you've articulated here today, the judicial philosophy of separate branches of government, as you so eloquently described our constitutional scheme, our federalism that really should have led the court to respect the Wisconsin Supreme Court's decision and the Wisconsin governor's decision, and to stay in its lane, as you have put it so well. The fact is, there has been a lot of progress, and we see it in this hearing room. But there is a lot of work still to be done, and there's a lot of reason for folks to feel even some anger at what we've seen on voting rights and on resegregation in some areas. So I am really excited, as I've indicated, and joyful at the great landmark and the historic accomplishment that your nomination represents and reflects. And I hope, as I've said, that not only will you make the court look more like America, but hopefully think more like America. And I want to thank you for your very hard work, all of what you personally have done, because you as a person have done it. And history has given you this opportunity. Your parents have helped to make it possible. Your family story is so powerful. but you've really earned it. And we're grateful to you for providing all of us that role model. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Hawley.
Thank you, Mr. Chairman. Judge, good to see you again.
Good to see you, Senator.
We don't have a lot of time, so let me just get straight into it. Senator Cruz was asking you at the end of his time and questionings about United States versus Stewart. This is the case where Neil Stewart tried to cross state lines to rape another person's 9-year-old daughter. He had 6,700 images and videos of egregious and brutal child pornography. The government recommended 97 months. The guidelines said 97 to 121 months. You came in at 57 months. Senator Cruz asked you why. The chairman wouldn't let you answer. I thought maybe you'd like to answer now.
Thank you, Senator. No one case can stand in for a judge's entire record. I have sentenced more than 100 people in a variety of egregious circumstances. In every case, and especially cases that involve the kinds of acts that you're talking about, the kinds of evidence that I had to deal with as a judge, in every case, I am balancing the factors that Congress has determined are appropriate and required for a judge to make a determination. The data points that Senator Cruz pointed to that you may have in front of you don't account for all of the information that was before me as a judge and the authority that you all, Congress, and your prior confirmation when I was a district judge provided for me to exercise my judgment. And I treated those cases and every case very seriously and imposed a sentence that was sufficient but not greater than necessary to promote the purposes of punishment.
Would it surprise you to learn that Mr. Stewart's a recidivist? He was warrants issued again for his arrest just 3 years after you sentenced him.
Would it surprise me?
Yeah. Would it surprise you?
You know, Senator, there is data in the Sentencing Commission and elsewhere that indicates that there are recidivism, serious recidivism issues. And so among the various people that I've sentenced, I'm not surprised that there are people who reoffend. And it is a terrible thing that happens in our system.
Yeah, indeed it is. Let me ask you about the Hawkins case. You and I talked about this yesterday. You've been able to think about it overnight. This is a case where you had an 18-year-old who possessed and distributed hundreds of images of 8-year-olds and 9-year-olds and 10-year-olds, and you gave him, frankly, a slap on the wrist sentence of 3 months.
Senator,
Do you regret it?
I don't remember whether it was distribution or possession. In
It
the
was
law,
both. Do you regret it?
in the law, there are different crimes that people commit.
Judge, you
in
gave
this
him 3
area.
months. My question is, do you regret it or not?
Senator, what I regret is that in a hearing about my qualifications to be a justice on the Supreme Court, we've spent a lot of time focusing on this small subset of my sentences, and I've tried to explain.
You regret that we're
Many
focusing on your
times-
cases? I don't understand.
No. I'm talking about the fact that you're talking about
Child pornography
7
cases?
very serious cases.
I'm glad we agree on that. Don't you think we should be focusing on
Some of which involve conduct that I sentence people to 25, 30 years.
3 months
for-
in this case, Judge? Do you regret it? You haven't answered my question yet. Do you
Senator.
regret this sentence?
Senator, I would have to look at the circumstances. What I'm telling you,
You know the circumstances. We discussed it for half an hour yesterday. There's a 55-page transcript, which I'm sure you've read. You
I
lived
did
it.
not- I
As
did
you've
not-
emphasized to this committee over and over, you've lived it, right? You said that you've been through all of this. You've looked at all of the images. You're the one who's had to endure all of it. You gave him a 3-month sentence. I just wonder if you regret it or if you stand by it. I mean, do you stand by that sentence?
Senator, in every case, I followed what Congress authorized me to do in looking to the best of my ability at all of the various factors that apply, that constrain judges, that give us discretion, but also tell us how to sentence. And I ruled in every case based on all of the relevant factors.
So you don't regret it?
No one case, Senator, can stand in for a
Now, I'm not asking you that.
entire
I'm asking if
record.
you regret this sentence in this case. And it sounds like the answer is no. But I want to tell you, I regret it. I regret that you gave him only 3 months. Let me read to you what you said about these kinds of cases. In fact, to this defendant, you said, make no mistake, Mr. Hawkins, the children you saw in those pictures were not willing participants in the conduct that you witnessed. They were being forced to commit unspeakable acts of sexual violence for the pleasure of the person who was filming and for the gratification of sick people everywhere, people who apparently have no shred of empathy for what this must be doing to the children who are being abused in this way. You go on. Some of the children you saw in those pictures will never have a normal adult relationship. Some of them will turn to drugs and prostitution and other vices to try to deal emotionally with the pain that results from the torture that they have experienced. And even those who manage to lead a somewhat normal adult life say they live in constant fear of being recognized. Some people are even unable to leave their houses because once those pictures are on the internet, they are there forever. And the victims can't do anything without worrying that every person that they meet has seen them in their most vulnerable state at the most horrible time in their lives. That's your words, pages 34 and 35 of the transcript. Powerful words, Judge. I just don't understand why after saying this and believing this, you could give this guy 3 months in prison when the probation office that we've heard so much about recommended 18 months. Even the probation office recommended 18 months. Do you have anything to add?
No, Senator.
Let me ask you about your policy of not giving enhancements when there are prepubescent children, like there were in the Hawkins case, who are 8, 9, 10 years old, when there are prepubescent children involved. I'm just struggling to understand this. You said it in Hawkins. You said that you weren't going to give him an enhancement. You weren't going to make his sentence any tougher, despite the fact that we had all of these terrible videos that you and I talked about at length yesterday. This is page 38 of the transcript, just so that we're all following along. You said, in your case, I don't feel that it is appropriate necessarily to increase the penalty on the basis of your use of a computer, and we've talked about that, or the number of images or prepubescent victims as the guidelines require, because these circumstances exist in many cases, if not most, and they don't signal an especially heinous or egregious child pornography offense. You said the same thing in the Cooper case just last year. This was an individual, Cooper, who was 30 years old at the time of his sentencing. He pleaded guilty to distributing child pornography. He posted between 3 and 4 dozen images of child exploitation to Tumblr, where it could be accessed publicly. The government said, and I'll quote from the transcript in that case, page 37, when his devices were found, including the computer, within the computer and on an untitled folder were many, many, many videos. The nature of these videos went well beyond mere child pornography. The government says, I don't mean to make light of the content of any child pornography, but rather to say that the content of those videos is on the more egregious or extreme spectrum of the child pornography videos that are encountered in these cases. And yet, when you sentenced him, you said, I'm quoting now from the transcript in Cooper, I'm really reluctant to get into the nature of the porn. And then later, it's very difficult to assess how different Mr. Cooper's images are than those of other similarly situated child pornography defendants, such that I, without going into looking at them, and I'm not an expert, you say. So you say, while I understand the government's arguments, Mr. Miranda, the government's arguments in that regard, I don't find them persuasive from the standpoint of characterizing this as an especially egregious child pornography offense. Help me understand this, Judge. Why is it that what's your policy disagreement with the guidelines treating images, videos, pornographic images that have small children, infants, 7, 8, 9-year-olds? Why won't you give an enhancement for those? Help me understand that.
Thank you, Senator. I'll make 2 responses. First, that's not my policy disagreement. I don't know why you've characterized that in that way.
Well, wait a minute. You say right here in the cases. I mean, this is what I want to make sure that we're talking about the same thing here. This in the Hawkins case, I don't feel that it's appropriate necessarily to increase the penalty on the basis of your use of a computer or the number of images or prepubescent victims. And you say the same thing in Cooper.
Senator, two observations. One, I am sentencing in every case. I have policy disagreements with certain aspects of the operation of the guidelines that I lay out in every case as Congress has required and as the Supreme Court permits in light of my experience, not only as a district judge, but also on the Sentencing Commission, which did a report about the operation of the guidelines. Second, you've read extensively from the government's argument in this case. You've not provided information from the probation office or the defense. And when
I
a
don't have the
judge,
probation office report.
no, excuse me, Senator, the probation office provides a recommendation. There has been information gathered about what a recommendation was given in each one of these cases. I don't have that information here, but what I'm saying is that in every case, the judge is not just hearing from the government. The judge is not just evaluating what the government says in these cases. In every criminal case, a judge has to take into account all sorts of factors, including arguments being made by the defendant, by the government, by the probation office. So I understand that in certain cases, the government may have made an argument, but there are other people in our criminal justice system who make arguments, and the court evaluates everything as Congress has directed. And no one case can stand in for my entire record of how I deal with criminal cases or did when I was a district judge. I have law enforcement in my family. I am a mother who has daughters who took these cases home with me at night because they are so graphic in terms of the kinds of images that you are describing. They give you not only the actual videos, which you can ask to see, but they describe in the briefs in detail what these videos show. So I am fully aware of the seriousness of this offense and also my obligation to take into account all of the various aspects of the crime as Congress has required me to do, and I made a determination seriously in each case.
What I'm trying to understand is why is it that you say multiple times that just because there are prepubescent victims in Cooper, in Hawkins, that does not signal that this is a heinous or egregious child pornography offense, and you're not going to apply any sentencing enhancements that the government's asking you for? The sentence gets to be less because you say, I'm not going to apply. The government asked for enhancements related to prepubescent children, related to the nature of these images. You say, I'm not going to apply it. But I get what you're telling me is, I guess, that you don't have a policy objection. I mean, why didn't you apply the enhancements as they were asked for?
Senator, I've answered this question many times from many senators who've asked me, so I'll stand on what I've already said.
So you have nothing to add about why these crimes, why these images, in your view, do not signal an especially heinous or egregious child pornography offense. That's Hawkins. You say in Cooper, I understand the government's argument, but I don't find them persuasive, the fact that there were prepubescent children, from the standpoint of characterizing this as an especially egregious child pornography offense. That's page 58. Let me ask you this. You said to Senator Graham earlier today that you were trying to do what's rational, and you didn't in sentencing in these cases, and you didn't think it was rational to sentence people who had thousands of images by using a computer to the sentencing guidelines, to the mandatory range. I'm sorry, it's not mandatory, to the no longer mandatory range, the discretionary range.
No, Senator, I said the guidelines system is designed to be rational.
Okay, so let me ask you this. Why isn't it rational to sentence people who have thousands of images on a computer to more time as opposed to somebody who has one or two pictures in the mail? In other words, the more images there are, why wouldn't you want to sentence that person to more time rather than less? Why isn't that rational?
Senator, I've answered this question and I'll stand on what I already answered.
So, but your answer is what? I mean, refresh my memory.
Senator, I've answered this question. I've explained how the guidelines work and I'll stand on my answer.
But the guidelines are not mandatory. I wish they were, but they're not. The Supreme Court made that determination. I'm trying to understand why you think it's rational not to sentence criminals based on the number of images they have. You say that this is a policy disagreement that you have with the guidelines. This gets to the core of your judicial philosophy. You served on the Sentencing Commission where you recommended changes to the guidelines based in part on this policy disagreement. So I think it's relevant and indeed vital we understand what the policy disagreement is. That's what I'm trying to get at here.
Senator, I previously explained what the policy disagreement is and I will stand on my answer.
So you're not going to answer my question?
No, I've answered your question in my answer.
You
is
haven't
I've
answered my question. I'm
explained-
sitting here asking you and you're declining to answer.
I've explained how the guidelines work. I've explained that the guidelines were developed at a time in which the commission of this crime was different than it is today. I've explained that Congress has not intervened to revise or direct the commission around how to deal with the changes in the commission of this crime. And so judges all over the country are grappling with how to apply this guideline under these circumstances. And there's an extreme amount of disparity. And in each case, a judge has to look at all of the factors, not just the guidelines, not just what the government asks for, but the recommendations of the probation office, the arguments of the government and the defense, the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote the purposes of punishment, which include things like rehabilitation. Also, in every case, Congress has authorized judges to impose not only terms of imprisonment, which are a very important part of the consequences for these crimes, but a range of other preventative kinds of measures which courts impose in cases to prevent these defendants from repeating these egregious, this type of egregious conduct. And I talked to each defendant, as you have quoted, explaining to them the harms that their crimes caused. And I imposed not only a term of imprisonment, but also all of the other consequences of the offense, to include decades of supervision, restrictions on use of a computer, and the like. That's my answer. I've answered it many times. Do you have other questions for me?
Yeah, I do.
to answer?
I do, because I want to try to understand when you talk about the guidelines being outdated and outmoded. I understand that they were written, the initial guidelines were written at a time when computers were not common. Everybody didn't have one. Certainly didn't have phones in every pocket like we do now, smartphones. So I understand that. I also understand that the number of images, sexually exploitative images of children on these devices has exploded. And so I'm trying to get at what Senator Coons earlier characterized as a pretty fundamental policy question, which I think is the correct characterization here. I'm trying to understand your view on why it is that while the number of images available on these things has exploded, that sentencing shouldn't track that. You see what I'm saying? I mean, you've made the argument, if I understand you right, and I want you to correct me if I'm wrong, you've made the argument that, well, look, the guidelines were written at a time when this stuff was like, it was an individual picture, it was, magazines, whatever. Now, almost every offender, I think this is the argument, so you correct me, almost every offender, because of the nature of this, they've got tens, hundreds, sometimes thousands. I mean, partly because of the nature of this. My question to you is, wouldn't we want to deter that? Isn't that a reason to impose tougher sentences? I mean,
Senator,
go ahead.
the Congress has every ability to do that. What's happening now is that you have a guideline that has gradations in it for the number of images that ends up being, when you look at the scale, something like the difference of 10 years. I don't know exactly what it is, but each 2-level enhancement is like several years. And the gradations are like 0 to, and again, I don't have it in front of me, but it's like 0 to 50 pictures, 50 to 100 pictures, 100 to 150 pictures, set up at a time in which the male was the primary mode of possession and distribution. And so if somebody had 50 pictures, they, according to Congress and the commission at the time, deserved an extra 10 years in prison. Now, with that scale, everybody's at the top immediately, just because of the nature of the internet. So you're not differentiating using that scale anymore, given the way this crime is committed. And so judges are having to decide, how are we going to deal with the penalties and do our jobs to impose sentences that are sufficient but not greater than necessary under these circumstances.
Yep. Thank you, Judge. I'll just say in closing that I appreciate that answer, and I understand that as a policy matter. I just think we disagree. I think that the more images are there, the more punishment there should be, and I want to see this deterred. And I just think we've pretty fundamentally disagreed. I've enjoyed our exchanges. Thank you for your candor, and I appreciate it. I just disagree with you on the law. Thank you, Mr. Chairman.
Senator Hirono?
Mr. Chairman. Mr. Chairman.
Senator Hirono's turn.
Mr.
Thank you, Mr.
Chairman, I'm
Chairman.
asking to be recognized to make a point to the chairman.
No, Mr. Chairman.
I believe he recognized me. May I proceed?
Mr. Chairman,
Mr. Chairman, I waited my turn on here, and I've been on this committee for 47 years. I think we ought to follow the regular order.
Mr. Chairman, the witness just said that we cannot understand those
I'm
cases
sorry,
without the
Senator.
pre-sentence
I don't want to
reports.
go through this again.
I have a letter that I want to enter into
There
the
are rules
record
in the
that's
committee
signed
that
by
should
10
be
senators
followed.
on this committee. Are you not even going to allow a letter from 10 senators
You
on
wanna
this committee?
send any letter, you can do it. by
This
hand,
letter
by
that is
mail.
signed by 10 senators on the committee addressed to you makes the point that the White House gave you probation information for Democrats that was not provided to the minority on this committee. And just now, Judge Jackson told Senator Hawley, you cannot understand these cases without reading the probation reports. 10 senators on this committee are asking the chairman
Mr.
to
Chairman,
provide those reports so we can do what Judge Jackson
Mr.
just
Chairman,
said, which is
I
to
know
assess
the-
those reports. And
Mr.
here is the
Chairman,
letter.
I know
I
the
ask
ju-
unanimous
know the
consent to
junior
be admitted to
senator.
the record.
I know the junior senator from Texas likes to get on television, but most of us have been here a long time trying to follow the rules. And he could very easily hand you a letter to go in the record. He's saying he's doing this to help Senator Hawley. Senator Hawley could have put it in, and he didn't. But let's get back to regular order.
Senator Hawley
God,
didn't
so-
write the letter. Mr.
Let's get
Chairman, I
back to
ask
regular
unanimous
order.
consent that it be admitted to the record.
Senator Hirono.
Thank you.
Are you denying consent?
Thank you, Mr. Chairman. Aloha, Judge Jackson.
Aloha.
I'm going to try and spread some aloha into this room. I'm taking a lead from my friend Senator sitting to my left. Well, at least you and I are very color coordinated today. So since 2018, I have been asking every nominee that comes before the committees on which I sit the 2 questions that I asked you at the start of my time, namely whether or not they have a history of sexual assault or harassment. This is something I started in 2018 to make sure that harassment and abuse that women mainly have put up with since, as far as I'm concerned, time immemorial, didn't continue to get swept under the rug. I found these questions to be important for nominees to the judiciary. As Chief Justice Roberts stated in his 2017 year-end report on the federal judiciary, events in recent months have illuminated the depth of the problem of sexual harassment in the workplace, and events in the past few weeks have made clear that the judicial branch is not immune. Here are just a few examples of abusive practices by federal judges. In December 2017, 6 former law clerks and staffers accused Ninth Circuit Judge Alex Kozinski of subjecting them to a range of inappropriate sexual conduct and comments. In September 2019, the 10th Circuit Judicial Council issued an order finding that District Court Judge Carlos Mejia, apologize if I mispronounce his last name, had harassed multiple employees over a period of years, including by subjecting them to sexually suggestive comments, inappropriate text messages, and excessive non-work-related conduct. In February 2020, former law clerk to the late Ninth Circuit Judge Stephen Reinhardt accused the judge of a months-long harassment campaign. And these are a few of the cases that we know about. There are undoubtedly many more we don't know about, both because of the power imbalance between federal judges and their clerks and employees who often rely on connections and recommendations to advance in their careers, and because of the lack of legal recourse available to the judicial employees. Many may not realize this, but federal judicial branch employees are not protected by the foundational federal statutes, such as Title VII of the Civil Rights Act of 1964, that prohibit discrimination and retaliation. And that's why I introduced, along with Chair Durbin and Senators Whitehouse and Murray, the Judicial Accountability Act, which would ensure the more than 30,000 employees of the federal judiciary have strong statutory rights and protections against discrimination, sexual harassment, retaliation, and other forms of workplace conduct. I know you can't comment on legislation, so I won't ask you whether you support the Judicial Accountability Act. Instead, I'd like to hear what you do to make sure your chambers is a safe, inclusive place to work.
Thank you, Senator. I, as you know, have been a judge now for almost a decade. And I take my responsibilities not only to hear and decide cases seriously, but also my responsibility as an employer, that I bring law clerks into my chambers. I was a law clerk to 3 wonderful federal judges who were role models for me, and I try to act as a role model to my law clerks. I try to bring in people who have the respect of others, people who come with strong recommendations, people who I think will get along with one another, and certainly people who I think will get along with me. And we create a little group, a working group, and I think that it's worked out well.
And I would think that you would make sure that there are no instances of inappropriate behavior, sexual harassment from any of your clerks or employees.
That's absolutely correct.
During our courtesy meeting, I enjoyed learning more about your background and family. And of the 9 sitting justices of the Supreme Court, only 3, Justices Alito, Breyer, and Kagan, were educated in our public school system. And you would, as far as I'm concerned, make a welcome addition to the court from that standpoint as a public school graduate myself. So public high schools educate people from all backgrounds, and most people go to public schools. Most people don't get to go to private schools. So your classmates probably came from different racial and ethnic backgrounds, incomes, social statuses, academic abilities, athletic abilities, among others. How, if at all, has your public school experience shaped the person you are and your approach to the law?
Thank you, Senator. I was very fortunate to go to public school in Miami, Florida. I had a wide range of classmates, and it was a wonderful opportunity to get to know people who were different than me, and to learn at the end of the day that they were not so different than I am, even if they came from different backgrounds. And I've talked a lot about my debate team. That was one of the activities that I engaged in and spent a lot of time with my colleagues on the debate team and with my wonderful coach. And you learn how to support each other, how to speak across difference, how to communicate with different kinds of people. And it was a wonderful experience. And as I've mentioned, in many ways different than the generation before, who in Florida were segregated by law.
So I take it that not only did you have, I would say, a broad experience of encountering people from all different walks of life and backgrounds, but there was still commonality that you had.
Very much so.
And that is very much exemplified in your approach to your work. I also talk with you about the importance of the creative part of our lives, because I think lawyers tend to be very left brain, and I know that you are a very well-rounded person. And so I asked you, what do you do to pay attention to the creative side of your life?
Thank you for the question. I took up, not too long ago, but took up the fiber arts, as they say. My mother is an expert crochet artist. She makes beautiful pieces of all kinds, and I always wanted to do that. I always wanted to, and she tried to teach me when I was younger, and it didn't quite turn out. But as I have gone along in my career and wanting to have some sort of a creative outlet, and especially in times of high stress, I started pining for something to do to express my creative side. And I bought a book on crochet. I talked to my mom. I started making hats and scarves, and then I moved to knitting during one of my confirmation hearing scenarios, because I needed something to keep my mind off of the stress. So I have a basement full of yarn if you'd like to come over.
I think that's another way that you're connecting to the people who really mean a lot to you. The creative outlet is really important to me because in a changing world, I think it is our ability to be creative in our approaches and how we think about things that will enable us to deal with the rapid changes that happen every day in these days. I view you as a consensus builder. And so I know that in your work with the Sentencing Commission, you really worked hard to come up with some 95% of the time, in this very diverse group, there was consensus in your recommendations. How important do you think consensus is on what I characterized yesterday as a very ideologically split Supreme Court?
I think consensus is very important. It was one of the things that I most admired about having the opportunity to work for Justice Breyer as a law clerk, to observe his process for reaching out to colleagues and trying to collaborate in his thought process about the outcomes of cases. And it's something that I tried to emulate when I was on the Sentencing Commission, which, as you said, is a very diverse body. I saw in that context the importance of trying to reach common ground with respect to your determinations.
Mr. Chairman, thank you very much. To illustrate the kind of broad support that this nominee has, I would like to enter into the record 2 letters, one signed by 1,000 public defenders from all across the country, and another signed by 48 prosecutors from across the country. Judge Jackson, I have very much enjoyed the
Without
privilege
objection.
of talking with you. Thank you, Mr. Chairman. And it will be my privilege to support your nomination.
Thank you,
Aloha.
Senator.
Thank you very much, Senator.
Mr. Chairman,
Senator from
yeah, I have
Iowa.
a letter here signed by members on my side of the aisle I'd like to put in record.
Without objection. I'd like to comment. I had a chance to review this letter for the first time just a minute ago. There is apparently a concern on your side, Mr. Chairman, about whether you have on your side of the aisle access to all the information that we have on this side of the aisle and all the information that's in the possession of the White House. During a break earlier today, I met with the ranking member, Senator Grassley, his staff, and with White House staff to discuss it. Here's my understanding of what has transpired. Last Wednesday evening, the senator from Missouri selected a handful of Judge Jackson's more than 1,000 district court cases to claim that Judge Jackson, quote, endangers our children, close quote. On Thursday, the next day, the White House contacted Judge Jackson's chambers to request the probation office recommendation in each of the cases. I underline probation office. That probation office provided a chart reflecting these recommendations. This is the sum total of what was provided. They shared with the White House from the chambers. When the senator from Missouri continued to raise questions and request the probation office's recommendation in these cases, the probation office provided this chart reflecting those recommendations, which was shared with the White House. When the senator from Missouri continued to raise questions about Judge Jackson's sentencing record, my staff asked the White House for information about the probation office recommendations. These are just numbers for each one of the cases. That's all that is. The White House and my office didn't have this information earlier because we didn't know the senator from Missouri was going to make this claim in the first place. Once the Republican side requested the same information, my staff shared it within minutes. So now your side, Senator, has exactly what the White House and the Democratic side has. The same chart provided by the probation office. And I might add that some of this had been published in the press and Washington Post and other places, but it consists in each case of the case number, name, the probation office recommendation for custody, the sentence imposed custody, probation office recommended supervision and release, and the supervision and release imposed. All of that information has now been shared equally. Some information on the other side, on the Republican side, includes frequent reference to transcripts, which we don't have on this side. And the reason being, we didn't anticipate this objection from the senator from Missouri and request that information. Now, the letter also goes a step beyond, which I think is a very important decision for this committee to make. This request for pre-sentence reports from each of these cases. Now, these pre-sentence reports are typically filed under seal. They can contain highly sensitive personal information, not just about the defendant, but about innocent third parties and victims. We've spent a lot of time here reflecting on these terrible crimes. Everyone has acknowledged how terrible they are and how damaging they can be to the victims. We have heard story after story, and I don't question a single word that was spoken in sympathy for these same victims. I would not want it weighing on my conscience that we are turning over these pre-sentence reports to this committee for the first time in history, and that information out of this, or because it was released, would somehow compromise or endanger any victim as a result of it. This information was not requested before. It's never been requested by this committee. And I think we ought to think long and hard about whether or not we even consider going into pre-sentence reports. So I'm going to take this matter up with our side, and I'm sure you will with your side. I have your letter requesting it. As far as this information, you have exactly what we have, no more, no less. In terms of pre-sentence reports, this is a critical policy question, which ought to be carefully weighed. It goes way beyond, I'm sorry, Senator Judge Jackson, it goes way beyond your nomination. And I want to make certain that we don't take a step here that endangers the lives or well-being of innocent people.
Mr. Chairman. Since you just responded to the letter that I wrote and was submitted on behalf of 10 senators, I will point out that in Judge Jackson's answer to Senator Hawley, she said that he and this committee did not have sufficient information to assess her sentencing decisions because we heard the arguments of the prosecutors in the transcript, but we did not have the recommendation from the probation office. And what she testified under oath is you can't understand why she issued her sentences without having those probation reports. You are right. that there can be sensitive victim information in those reports. And everyone on this side, I'm confident, would agree to redacting out any information that would violate the privacy of a victim. But Judge Jackson has told us it is relevant to understanding those cases, and that's why 10 of us have requested we have those reports, and there's explicit statutory authority for us to do so that is cited in the letter we just submitted.
Senator, I don't know where other members of your caucus stand on the basic question of this nomination. They can decide on their own, and they will, and they should. That is their responsibility. I think I know where you're headed. And I would just suggest that we ought to think long and hard, my friends, about members of the Judiciary Committee endangering the lives of innocent people to pursue this line of questioning. We spent 2 days, 15, 16, 17, 18 hours, and a large part of it on this issue. I don't believe these pre-sentencing reports are going to change anyone's disposition if they're going to vote on this issue. And I do not want it weighing on my conscience that I gave the green light to release this information so that it might endanger the lives of innocent victims. I'm sorry. That's a bridge too far for me. I think the issue before us on sentencing, you each had a chance to hear plenty of testimony on it. And I believe this should be taken up with the individual caucuses on both sides, if you wish. But that to me it's gone way too far, way too far. I don't want it on my conscience.
Mr. Chairman, if I might,
Senator,
when I agree with you, I've prosecuted literally thousands of people. I would have to go back. It's over 8 years. I can't remember the hundreds of sentencings I was at where we had pre-sentence reports over and over again. There were things in there that were sensitive, sometimes reflecting somebody who were putting their lives on the line to even give a report. Neither the defense counsel nor I as a prosecutor ever thought those would be made public. And we assumed the judges, we had judges across the political stripes who read them, kept the confidence of that. As a result, we knew that the reports were thorough. And a judge has the final say, but as a prosecutor, I might have a recommendation, but I never question a judge who might give a different sentence, because my responsibility as prosecutor, theirs was the sentence.
Senator Lee.
Yeah, might I just weigh in here? I totally understand the concern that you're describing relative to the confidential nature of pre-sentence reports. As a prosecutor and as a law clerk, I reviewed those with some regularity, and I understand the sensitivity of them. Let me suggest a couple of things. First of all, it's not unusual for us as a committee and as members of the United States Senate to review materials that would be inappropriate for public release. I don't think one of us is suggesting that. There are means by which we can review things in a classified environment and treat them as classified. We've done that with significant success in this hearing. Secondly, to the extent that wouldn't provide the level of comfort necessary, we'd also be happy to review them on a redacted basis. These are things that have become relevant in our conversations. We want to make sure that we have the facts, but not one of us wants to endanger anyone or to render public information that is sensitive in nature. There are abundant ways around that.
I would suggest that the information contained in these reports is dangerous to the victims and to the innocent people who are mentioned in these reports, and unnecessary at this point. It's never been requested by this committee, and it's merely a fishing expedition in dangerous territory. Classified settings, redacted versions of the reports. This has never happened in the history of this committee. And I would say, Senator, I will just tell you, I am not going to be party to turning over this information and endangering the life of an innocent person for a political quest to find more information. We have exhausted this topic. We've gone to it over and over again. And I think that this is a bridge too far for this committee. That's my personal feeling. I take it that Senator Leahy may agree with me in that regard. This nominee has been before this committee for 18 hours. I don't believe that this information is going to change anyone's vote. You can decide in your caucus what you want to do to go forward. I've told you my position. I want to proceed if I can. I thank the nominee for waiting for this colloquy, and I turn it over to Senator Cotton.
Judge, I want to return to the question of crime and specifically sentencing. In any of the cases where you've sentenced an offender below the guidelines, has that offender gone on to commit another crime after getting released from prison?
Thank you, Senator. When judges sentence, they often impose terms of supervised release. And there are times in which, when a person is on supervised release, they reoffend. There are also times when they don't. But even after the period of supervised release, the court doesn't continue to have any way of tracking or knowing what happens, because if they were to reoffend, it wouldn't necessarily come back to the same court or the same judge.
So you don't have a factual basis to know whether or not anyone you've sentenced below the guidelines has reoffended in the future?
Do I have a factual basis? I know that there are people who have reoffended while on supervised release. I can't remember whether any of them were guideline sentences, below guidelines, or above guideline sentences.
Okay. I know you've answered a lot of questions the last 2 days about sentences and sex crimes. I just want to be exact about this. In these cases, have you ever sentenced an offender above the guidelines recommendation?
I'd have to take a look at, I know that I have sentenced offenders to the guidelines if in the category of sex crimes in general. I know that I've given 30-year sentences for at least one offender, almost 30 years, 29.5. I've given, I believe, a 12-year sentence for someone at the agreement of all of the parties, which was a sentence that was a part of his plea agreement. I'm not remembering the others.
I understand you've sentenced in a lot of cases. I want to return briefly to the Hawkins case. Wesley Hawkins, as a reminder, was convicted of a child pornography offense in 2013. The sentencing guidelines for this offense called for a sentence of 97 to 121 months, or 8 to 10 years. The prosecutors asked for 24 months. You sentenced him to 3 months. We've heard a lot about this case and your 3-month sentence of Wesley Hawkins, but you got another crack at him in 2019, Judge. In 2019, you sent Wesley Hawkins back under conditions of confinement with the Bureau of Prisons for 6 months with additional restrictions on his computer usage. That's twice the amount of time in custody that you sentenced him to in 2013. What did Wesley Hawkins do in 2019, Judge?
Oh, I don't remember, Senator. I have a lot of defendants who I've sentenced who are on supervision, who violate conditions of supervision. If in our system, someone like Mr. Hawkins, especially given the crime, the egregious crime that he committed, was likely on a very long period of supervision. And during that time, he would likely be under computer restrictions for 10, 20 years or something, where he's not allowed to do certain things with a computer. And a probation officer is monitoring. They put software on the computers of individuals who are who have these kinds of conditions imposed, and that restricts their ability to access certain information on the internet. And so it's not uncommon for a probation officer to report violations of supervised release, not just in this area, but across all crimes. And then the court has to determine how to handle that. And you could, in fact, send someone back to jail for violating conditions of supervised release that are not themselves criminal behavior. It's just, you know, the court says in their supervision order I'm imposing a 20-year or whatever it is, sentence of supervision. And during this time, you're not allowed to access your computer, et cetera, et cetera. So if he were to do that, it wouldn't be additional criminal behavior, but it would be a violation of my order. And when he comes back to the court on violation, the court has factors that we look at to determine whether or not to treat that essentially as the kind of violation that would require him to go back to jail.
Okay. Judge, yesterday we had an extended conversation of your sentencing of a man named Keith Hodges, a fentanyl kingpin. That sentencing occurred in 2018. You had very detailed recall of that sentence. To my knowledge, that's the only time anyone's asked you about Mr. Hodges' sentence. You've been asked repeatedly over the last 2 days about the Hawkins case. It's been in the news, as Senator Durbin decided, for days on end. This resentencing happened in 2019, and now you're saying you don't have any recollection of it. Let me see if I can refresh your recollection. This is the order you signed, Judge, on April 17th, 2019 in USA v. Hawkins. And it says that you concur with the recommendation of the probation office to return him to a residential reentry facility for 180 days and to engage in various kinds of computer monitoring and computer monitoring and search. There's your signature over there, Judge. You really don't remember what?
Senator, that is a very, very common thing that judges do. I've sentenced over 100 people, and supervised release, which is the kind of post-incarceration condition that judges ordinarily impose, is something that's done on a standard form, which is what that is.
I understand you've done a lot, Judge, but none of them have been the centerpiece of your hearing for the last 2 days. Do you really expect this committee to believe that you don't remember what happened in this Hawkins case when it came back before you?
Yes, Senator, I do expect you to believe that's my testimony.
Well, I don't find it credible, Judge. It's been in the news for days. Senator Durbin has cited it being in the news for days. You've been asked about it probably more than any other case you've ever had. And I just don't find it credible that you weren't prepared for that matter in 2019. You know what I think? I think he got caught with child pornography again, and he wouldn't have if he had been in prison for the 8 to 10 years the guidelines called for in 2013 when you first sentenced him. Let's turn, though, to your work for detainees at Guantanamo Bay. First off, let me just ask, do you think most detainees at Guantanamo Bay were mostly terrorists or mostly, I don't know, innocent goat farmers?
Senator, it's impossible for me to answer that question. The people at Guantanamo Bay had been accused by the government of engaging in terrorist activities and therefore classified by the executive branch as enemy combatants.
Okay. Do you think America would be safer or less safe if we released all the detainees at Guantanamo Bay?
Senator, I'm trying to figure out how to answer that question. 9/11 was a terrible attack on our country, and the executive branch, pursuant to authority that the Supreme Court said it had, designated people as enemy combatants and sent them to Guantanamo Bay. The Supreme Court also said that anybody who was so detained could seek review of their detention. And as a federal public defender, my role and responsibility was to make arguments in defense of the Constitution and in service to the court that was trying to assess, based on the authority given to it by the Supreme Court, whether or not people were adequately classified, what the legal circumstances were, how these habeas petitions were going to be processed. This was a series of legal challenges in a novel environment that federal public defenders and lawyers across the country were engaged in helping the court to evaluate so that we can understand what the Constitution required in this time of emergency.
Okay, so no opinion on whether America would be safer or less safe if we released all the detainees from Guantanamo Bay.
Senator,
Okay.
America would be less safe if we don't have terrorists out running around attacking this country. Absolutely. America would also be more safe in a situation in which all of our constitutional rights are protected. This is the way our scheme works. This is how the Constitution that we all love operates. It's about making sure that the government is doing what it's supposed to do in a time of crisis. As Justice Gorsuch said, the Constitution is not suspended in times of crisis. The government still has to follow the rules. And so criminal defense lawyers make sure that in times of crisis, the government is following the rules.
Okay, let's turn to the actual cases. How many of these terrorists at Guantanamo Bay did you represent?
When I was a defender, 4 cases were assigned to me in our office. I don't know how many cases came into the office in total, but
You personally had 4.
I was assigned to them along with another defender who worked on the same cases. She was more senior. She did all of the sort of fact gathering related to the cases. And as an appellate defender, I worked on the legal arguments.
Did you ever represent any of the detainees at Guantanamo Bay when you were not a public defender?
One of the people who I'd represented while I was in a federal defender, his case got spun off and taken up by a law firm. Law firms around the country were also engaged in this work.
I'm well
at the
aware of what
time.
law firms were doing at the time.
Yes. And I left the federal public defender's office. I joined a law firm, and one of the people that I had represented was now at that law firm. They had him as a client.
That's
and
Mr. Al-Salwam.
Al-Qahtani
Al-Qahtani was the one.
was the one
But
who,
just coincidentally, both he and you went to Morrison and Forrester.
yes, Senator.
Okay. What about Mr. Al-Salwam?
I don't know what happened to Mr. Al-Salwam.
You were listed as counsel for 2 years during your time at Morrison and Forrester.
What happens is when you leave from any place, firms or government service, you have to let the court know, or their records reflect where you are in the system, and not so much the case in terms of your address.
So
So-
to go back to Mr. Al-Qahtani.
Yes.
He just coincidentally, it's a small world, went to Morrison and Forrester at the same time you did, and then you represented him, and you did file multiple motions on his behalf.
So I don't know if it was at the same time. I'm not sure.
But you did file multiple motions for him,
I only
2008 and 2009.
I don't recall whether it was multiple, but he was still at the habeas stage of the process. And I don't know when he came, because the partners who picked up the case were in Los Angeles. I was in Washington, D.C. They contacted me to say, oh, we see on the docket that you had previously represented him, and now you're with our firm. Will you assist us with looking at these briefs, working on these briefs? There were many lawyers who were working on the filings that you're talking about.
After you left the public defender's office, did you continue in your reputation of your client you had at the public defender's office?
I didn't continue my representation of any client. I left the federal public defender's office and then picked up Mr. Al-Qahtani through the circumstances that I talked about. And there were no other clients that I represented in that way.
I have to say, that sounds like continuation. You represented him at the public defender's office, and then you represented him in private practice as well. And you're telling us that's the only person you represented at both the public defender's office and in private practice?
Yes,
So you didn't continue to provide any kind of pro bono work for murderers or rapists or anyone else, but you did continue to represent this terrorist at Guantanamo Bay.
when I got to the firm and they told me that the case was there and they recognized that I was at the firm and had previously worked on the case, and by they, I mean the partners in the firm, they asked me as a member of the Supreme Court and appellate group of the firm, which is where what was my practice, if I would help review and work on some of the briefing that they were submitting on his behalf, given my familiarity with the case.
Were you representing him pro bono at Morrison and Forrester?
The firm takes on pro bono representations, which means that the person isn't paying. And
Let's turn to your amicus briefs. You had 2 briefs in Guantanamo cases, one for a think tank, one on behalf of a group of former judges. I think, as anyone who's done amicus work knows, sometimes the client seek out the lawyer, sometimes the lawyer seek out the client. For either of those amicus briefs, were you involved in any way in seeking or recruiting those clients or suggesting the idea for an amicus brief in the first place?
no, Senator.
Were both of those briefs done on a pro bono basis?
Yes, because the Supreme Court and appellate group in a law firm has paid clients and also has pro bono clients. And the briefs that I worked on were on the one brief was 20 former federal judges who wanted to make an argument in the Boumediene case that was in the Supreme Court. And one of them was a partner at my law firm. She was a former federal judge whose idea it was, and she knew the other judges and wanted our group to work on the brief. The other was not just one think tank, it was the Cato Institute, the Rutherford Institute, and the Constitution Project, an ideologically diverse group of nonprofits who wanted to make arguments in another case that the Supreme Court had taken up related to these issues, because all of this was novel and a lot of issues were being evaluated by the Supreme Court regarding the scope of executive authority during this time of crisis.
Okay, so you've done pro bono work for, on behalf of detainees at Guantanamo Bay. Have you ever done pro bono work for the victims of terrorism?
Senator, I'm not aware of any such cases in my law firm. I was in a group of lawyers that was often approached to ask, would you file a brief for some group? And I'm not aware that any victims of terrorism asked our firm to participate.
So we've talked a lot about the people you represent. Let's talk a little bit about the defendants in those cases and how you characterize them. I'll remind you that those were the President, the Secretary of Defense, and active duty Army officers. Senator Graham and Senator Cornyn said that you called them war criminals. You disputed that, and Senator Durbin has repeatedly denied it as well. And I'll concede you didn't use those exact words. You didn't say war criminals. But you did say in multiple court filings that they committed acts that constitute war crimes. I'm sorry, but I got to confess, I don't understand the difference between saying someone is a war criminal and saying they've committed acts that constitute war crimes. So can you explain that difference to me?
Yes, I will. Thank you for the opportunity. So when you file a habeas petition under our law, you can't file it against the United States because of sovereign immunity. The way our law works, you have to file it against individual officers in their official capacity. That's the way in which you're able to file a habeas petition. So whoever is the executive at the time becomes the named party in the brief. And a habeas petition is like a complaint in a civil case. It's making allegations to begin the litigation about the person's detention.
But Judge, official capacity, personal capacity, all that is just a bunch of procedural gobbledygook. These are the people that you said committed acts that constitute war crimes.
With respect, Senator.
I just don't understand the difference between calling someone a war criminal and saying they committed acts that constitute war crimes.
With respect, Senator, they were not sued in their individual capacity. We weren't making allegations about those individuals. And in fact, over the course of the case, the names changed. So later on, the habeas petition became against President Obama because he then became the executive for the purpose of the habeas petition.
I'm
So
well
it
aware the name changed. It
wasn't-
probably changed from Bob Gates or from Don Rumsfeld to Bob Gates as well. But they were not the ones in office. They were not the ones who were overseeing the government when you filed these suits and you said they committed acts that constitute war crimes. I don't understand how you expect this committee to believe that there's a difference between saying someone's a war criminal and saying they committed war crimes.
Thank you for the opportunity to explain, Senator. One of the allegations that had been publicly reported with respect to the group of people who were in Guantanamo Bay was an allegation concerning the use of torture. And when you make that allegation, you bring it under laws that themselves constitute crimes of war. That's the way in which the law works. So if you're writing a habeas petition and you say, upon information and belief, Mr. Al-Qahtani was tortured, that allegation is made under a law that says that there was a war crime that occurred as a result of that torture, and you're making that allegation against the United States, but because you can't sue the United States, the actual petition is named in the name of whoever's leading the United States at the time. So later in the course of this, it moved from President Bush, Donald Rumsfeld to President Obama. It's not about the individual. It's about the allegation that that Mr. Al-Qahtani, upon information and belief, had been tortured in the lead up to his detention.
I don't know, Judge. Sounds like a debate about how many terrorists can dance on the head of a pin to me.
Thank you, Senator Cotton. Ask unanimous consent to enter a letter in the record from 9 former national security officials defending Judge Jackson's Guantanamo representation. The signatories include former Attorney General Loretta Lynch, Department of Homeland Security Secretary Jay Johnson, and the former Judge Advocate General of the United States Navy, Senator Booker.
Thank you very much, Judge. After me, only 5 to go. But sit back for a second, because I don't have questions right away. I actually have a number of things I just want to say, because this has been not a surprise, given the history that we all know, not a surprise, but perhaps a little bit of a disappointment. Some of the things that have been said in this hearing. The way you have dealt with some of these things, that's why you are a judge and I am a politician, because you have sat with grit and grace and have shown us just extraordinary demeanor during the times where people were saying things to you that are actually out of the norm. I had to go up dais to ask some of my more senior colleagues about what I feel like is a dangerous precedent. People are taking 1,000 cases you've been over. Is that right? I'm sorry, I said you wouldn't ask you questions, but just give me
something like that.
Something like that. And from what I understand is that these cases often take days, weeks, sometimes months, right?
To decide in a case, yes.
There's a trial sometimes. And the folks are taking any of those cases and just trying to pick pieces out. And so my colleague, Senator Hawley, has been doing this all into the lead up and saying things, tweeting things that I think that a lot of us, when I was just trying to get some advice here, is this is what the new standard is going to be. That any judge coming before us that has ever chosen outside of the sentencing guidelines, below the sentencing guidelines, we're creating this environment now where I could make myself the hero of people who have been victims of some horrible crime and suddenly put whatever judge I want on the defensive by trying to drag out little bits when they have no context to the case. None of the facts. They're seeking to exploit the complexities of a criminal justice system, the reason why we have a third branch of government. I feel bad that there was a judge mentioned by name in this hearing that's from Senator Hawley's state. What is that judge going to think next time they have a complicated sexual abuse case that comes before them? and they know that they could possibly be called out if they go below the sentencing guidelines, which I showed you yesterday in my lack of chart. If you remember, I was uncharted. But that you are deciding completely in the norm. 70+% in many states of people are doing just like you did. But I'm a Democratic senator. I've never quoted from this very well-respected conservative periodical. This is the National Review. Very well-respected. They're not necessarily something I agree with all the time. But here's what the National Review, this is the title. Senator Hawley's disingenuous attack against Judge Jackson's record on child pornography. I'll just read the first paragraph. I would oppose Judge Ketanji Brown Jackson because of her judicial philosophy for the reasons I outlined last week. I addressed that in a separate post. For now, I want to discuss the claim by Senator Josh Hawley that Judge Jackson is appallingly soft on child pornography offenders. This is the kicker here. The allegations appear meritless to the point of demagoguery. I got letters from leaders of victims' rights groups, survivors of assault, all saying sort of the same thing with the National Review. Feel proud about yourself. You brought together right and left in this calling out of people that will sit up here and try to pull out from cases and try to put themselves in a position where they're the defenders of our children. To a person who has children, to a person whose family goes out in streets and defends children. I mean, this is a new low. And what's especially surprising about this is it didn't happen last year. You were put on a court that I'm told is considered like the second most powerful court in our land. And you were passed with bipartisan support. Nobody brought it up then. Did they not do their homework? Were they lax? Did they make a mistake? I wonder, as they ask you the question, do you regret? I wonder if they regret that they didn't bring that out. No. Why? Because it was an allegation that is meritless to the point of demagoguery. You are, I don't mean this in any way, because if anybody called me average, I would be upset, but you are a mainstream judge. Your sentencing, I've looked at the data, falls in the mainstream on everything from child sexual assault to all the other issues that people are trying to bring up. Some of these things that are being cast at you, that you called George Bush a war criminal, come on, that is painful. Especially because, as you said, the brief change, these are names that you have to put in. And we're talking about a real issue that goes to the core of our values, torture. Barack Obama was named once Bush left office. There is an absurdity to this that is, it is almost comical if it was not so dangerous. Because the next time a judge comes before us on the right or the left that has a body of work like you do, gosh, one of the some performance artists on our side could pull out one of the cases where they were below the sentencing guideline, say, for example, it was on something like as horrific as rape that we all agree is horrific, and they can suddenly put themselves as the defense. How dare we put someone who's soft on crime? Well, are you soft on crime? God bless America. I got this great text. I've become really good friends with the folks at the FOP from my negotiations. And this was my favorite text. You all got to get this. I think my brother Kennedy might get a kick out of this. He goes, things that are uncountable, stars in the sky, grains of sand on the beach, and the number of times Democrats will mention that the FOP endorsed Judge Jackson in this hearing. But let me mention it again. Just in case my people say you're rough on crime folks really want to try to make that stick. You were endorsed by the largest organization of rank and file police officers. You were endorsed by the bosses, the largest organization of chiefs of police. And you were endorsed by Noble, who I hope people find out more about that organization. You got uncles that are officers. You got a brother, not just an officer, who went to serve after 9/11. Your family's not soft on terrorism. He went out there to capture and kill and defend this country from terrorists. I actually sitting back here and finding this astonishing, but then I do my homework. I love that my colleague brought up Constance Baker Motley. You know, when she was getting to the floor of the Senate, they were trying to stop her with outrageous accusations. You know what the accusation was back then? She was a communist. Dragging up stories, trying to throw anything that they might stick. But this is what you and I know. Any one of us senators could yell as loud as we want that Venus can't return a serve. We could yell as loud as we want that Beyonce can't sing. We could yell as much as we want that astronaut Mae Jemison didn't go all that high. But you know what? They got nothing to prove. As it says in the Bible, let the work I've done speak for me. Well, you have spoken. You started speaking as a little girl, watching that man right there try to raise a family and study law while your mama supported everybody. You spoke in high school when you started distinguishing yourself. And you know what you said when they told you couldn't go to Harvard? Watch me. I went to law school. I didn't serve on the law review. You did. I didn't clerk at every level of the federal court. You clerked for a Supreme Court justice, one widely respected on both sides, which really shaped you. You left there and you went to private practice, and you know what you found? This is what you told me. That you had those tough choices that working moms have to make, the demands of a private law firm, raising your kids. It just didn't add up. You went before this Senate 3 times in a bipartisan manner. God bless America. We don't do that much stuff bipartisan around here. You went to become a public defender because you wanted to understand all aspects of the law. Who does that? We live in a society that's very materialistic sometimes, very, very consumeristic. You went into, did people become public defenders for the money? No. Your family and you speak to service, service, service. And I'm telling you right now, I'm not letting anybody in the Senate steal my joy. I told you this at the beginning. I'm embarrassed. It happened earlier today. I just look at you and I start getting full of emotion. I'm jogging this morning and I'm at the end of the block I live on. And I get terrified because I put my music on loud when I'm jogging, trying to block out the noise of the heart attack I'm having. And this woman comes up on me, practically tackles me, an African-American woman. And the look on her eyes, she just wanted to touch me because I'm sitting so close to you, and tell me what it meant to her to watch you sitting where you're sitting. And you did not get there because of some left-wing agenda. You didn't get here because of some dark money groups. You got here how every Black woman in America who's gotten anywhere has done, by being like Ginger Rogers said, I did everything Fred Astaire did, but backwards in heels. And so I'm just sitting here saying, nobody's stealing my joy. Nobody's going to make me angry, especially not people that are called in a conservative magazine demagogic for what they're bringing up that just doesn't hold water. I'm not going to let my joy be stolen because I know you and we appreciate something that we get that a lot of my colleagues don't. I know Tim Scott does. When I first came to this place, I was the 4th Black person ever popularly elected to the United States Senate. And I still remember a lot of mixed people, white folks, Black folks work here, but at night when people are in line to come in to clean this place, the percentage of minorities shift a lot. And so I'm walking here, first week I'm here, and somebody who's been here for decades doing the urgent work of the Senate, but it's the unglamorous work that goes on no matter who's in offices. The guy comes up to me, all he wants to say, I can tell, is, I'm so happy you're here. But he comes up and he can't get the words out. And this man, my elder, starts crying. And I just hugged him, and he just kept telling me, it is so good to see you here. It's so good to see you here. Thank you, thank you, thank you. I love my brother, Tim Scott. We could write a dissertation on our disagreements. He gave the best speech on race. I wish I could have given good of a speech. But talking to the challenges and indignities that are still faced. And you're here. I was in the White House with my Democratic colleagues, and I'm in my joy. I can't help it. and the president's asking our advice, who should we nominate and whatever. And I look at Kamala and we have a knowing glance, which we've had for years when she and I used to sit on this end of this committee at times. And then I try to get out to the president what it means. What it means. And I want to tell you, when I look at you, this is why I get emotional. I'm sorry, you're a person that is so much more than your race and gender. You're a Christian, you're a mom, you're an intellect, you love books. But for me, I'm sorry, it's hard for me not to look at you and not see my mom, not to see my cousins, one of them who had to come here and sit behind you. She had to have your back. I see my ancestors and yours. Nobody's going to steal the joy of that woman in the street, or the calls that I'm getting, or the texts. Nobody's going to steal that joy. You have earned this spot. You are worthy. You are a great American. Your hero is Constance Baker Motley. Mine, she has sat on my desk for my offices that I've held. She's my icon of America. Her name is Harriet Tubman. There is a love in this country that is extraordinary. You admitted it about your parents. They loved this nation, even though there were laws preventing them from getting together. When they were loving, there were laws in this country that would have prevented you from marrying your husband. It wasn't that long ago, it was last generation. But they didn't stop loving this country, even though this country didn't love them back. And what were the words of your heroes and mine? What did Constance Baker Motley do? This country that she saw insults and injuries, when she came out of law school, law firms wouldn't even hire her because she was a woman. Did she become bitter? Did she try to create a revolution? No, she used the very constitution of this nation. She loved it so much, she wanted America to be America. As Langston Hughes wrote, "Oh, let America be America again. The land that never has been yet, but yet must be the land where everyone is free." Oh, yes, I say it plain, America never was America to me, but I swear this oath, America will be. That is the story of how you got to this desk, you and I and everyone here, generations of folk who came here and said, America, I'm Irish. You may say, no, Irish or dogs need to fly, but I'm going to show this country that I can be free here. I can make this country love me as much as I love it. Chinese Americans first forced into near slave labor, building our railroads, connecting our country, saw the ugliest of America, but they were going to build their home here and say, America, you may not love me yet, but I'm going to make this nation live up to its promise and hope. LGBTQ Americans, from Stonewall women to Seneca, hidden figures who didn't even get their play until some Hollywood movie finally talked about them and how they were critical for us defying gravity. All of these people loved America. And so you faced insults here that were shocking to me. Well, actually not shocking. But you are here because of that kind of love. And nobody's taken this away from me. So you got 5 more folk to go through. 5 more of us. And then you can sit back and let us have all the debates. And I'm going to tell you, it's going to be a well-charted Senate floor because it's not going to stop. They're going to accuse you of this and that. Heck, in honor of your person who shares your birthday, you might be called a communist. But don't worry, my sister. Don't worry. God has got you. And how do I know that? Because you're here. And I know what it's taken for you to sit in that seat. Harriet Tubman is one of my heroes because the more I read about this person, the more, she was viciously beaten. For her whole life, she used to fall into spells, cracked skull. She faced starvation, chased by dogs. And when she got to freedom, what did she do? Did she rest? No, she went back. Again and again and again. The sky was full of stars. But she found one that was a harbinger of hope for better days, not just for her and those people that were enslaved, but a harbinger of hope for this country. And she never gave up on America. She fought led troops in the Civil War. She was involved in the suffrage movement. And as I came back from my run, after being near assaulted by someone on the street, I thought about her and how she looked up. She kept looking up. No matter what they did to her, she never stopped looking up. And that star, it was a harbinger of hope. Today, you're my star. You are my harbinger of hope. This country is getting better and better and better. And when that final vote happens and you ascend onto the highest court in the land, I'm going to rejoice. And I'm going to tell you right now, the greatest country in the world, the United States of America, will be better because of you. Thank you.
Thank you, Senator Booker. We're going to take a 10-minute break.
Thank you.
And come back and have the last 5 senators ask their questions.
Everything is great. You good? Yeah.
I'll get it. I just need you to sit where you're facing.
Yeah, you'll be there. You'll be in a walk. You'll be in Honolulu then. Oh my gosh. Lucky. I mean, I'll be staying at the lake. The Lalo. Oh, there's a double cheese.
Yeah. Excuse me, I'm gonna sit here so they can focus the cameras again.
Yeah.
It is, isn't it? Yeah. I can be the next judge. Yes, sir. Oh. James is focusing at his own back. He said it's hitting on, it's the focus is concentrating on the sign, he's picking up the sign, so he wants to manually change it backward.
You could just like.
Yeah, it's her. Yeah, it's her.
Committee will resume with Senator Kennedy of Louisiana.
Thank you, Mr. Chairman. Judge, I want to continue where we left off yesterday and try to get, if I can, get to the essence of this tension between judicial power and judicial restraint. You have testified, and stop me if I get this wrong, that judges should stay in their lane. And I think it's fair to say that one of your definitions of staying in your lane is that judges don't make policy. Am I right so far?
Yes, that is correct, Senator.
Then how do you explain or help me understand the following? We have a judicially created doctrine with no textual basis either in the Constitution or a statute called substantive due process. And through substantive due process, Our federal courts, let's just narrow it down. The United States Supreme Court has given itself the authority to read into the Constitution unenumerated, unmentioned rights. Not read the Constitution and say, well, there it is, freedom of speech. But these are unmentioned, unenumerated. Isn't that making policy?
Senator, the Supreme Court interprets provisions of the Constitution, and there are provisions of the Constitution that require interpretation because they don't just on the text in every circumstance answer the question before the court. So due process, what does that mean? And the Supreme Court has, the words due process do appear in the text of the Constitution. And the question is, what is covered by that provision? The Supreme Court, oh, sorry.
I was just
Go
going to say,
ahead.
but when they do it, aren't they making policy?
Well, Senator, the role of the judiciary is to interpret the law. To the extent that somebody argues to the court that there's been a violation of the due process clause of the Constitution, it is within the role of the court to determine what that means, whether the person is correct that what happened with respect to their case violated the due process clause. And so there's an interpretive function that is a part of the judicial function.
Here, let me see if I can put a finer point on this. It's not the right so much.
Mm.
It's how the right is created. That's why I asked you yesterday whether you think that these unenumerated, unmentioned rights ought to be decided by the people through their elected representatives versus the federal judiciary. Let's take two rights that I talked about yesterday, the right to assisted suicide, the right of a transgender woman to participate in women's sports. I can see how, I'm not predicting that it will, but I could see how the court, either through the due process clause or the Ninth Amendment, could find those rights in the Constitution. As we talked about yesterday, the Supreme Court looks to me like they've adopted the policy of there is no test for a fundamental right. There are several tests. And in Obergefell, Justice Kennedy cited with approval Justice Harlan's dissent in Poe v. Ullman, which says there's no test. We go case by case. And but I know there are tests, like I'll get the language here somewhere. I've got it. I don't want to look it up, but implicit in the concept of ordered liberty, and you've talked about that. Here's a new one that Justice Kennedy talked about in Obergefell. He said, inherent in the concept of individual autonomy. Well, I can see how if the court with 5 votes wanted to say, even though the right to assisted suicide or the right of a transgender woman to participate in women's sports, I can see how somebody, you're smart, you could write an opinion and say that's inherent in the concept of individual autonomy. And maybe, again, it's not the right. It's who's supposed to decide. And that's where the judicial restraint comes in. I mean, don't you think that the values of ordinary Americans and their ability to decide these issues are just as good as those of 5 members of the Supreme Court?
Thank you, Senator. There are policy determinations that are made by vote, and absolutely in the democratic process, people get to decide things. The question and the difficulty is when you have a constitutional scheme of government and you have a constitution that does protect certain rights, and it does so in a circumstance in which those rights, whatever they are, enumerated or not, are might be things that the people have disagreed with. That's the tension. That that although we have democracy as we do, and people vote and should absolutely, we also have a constitution that protects certain rights against the sort of majority will about those things.
But the rub, of course, is, I agree with everything you said, but the rub is these are unenumerated rights.
Yes.
They're read into the Constitution.
Yes.
And what troubles me, I'm not saying I disagree with all the rights that the Supreme Court has created, but I don't think we talk honestly enough about how those rights should be adjudicated. For example, I'm not asking you to comment on this. I think you already have. But when President Biden announced your appointment, or at least shortly before, he talked about, I want a judge that's going to read new rights into the Constitution through the 9th Amendment. And I'm sure some Americans are saying that's a good thing, but you got a lot of Americans going, hey, wait a minute. Supreme Court isn't elected. A couple years ago, Chief of Staff Ron Klain wrote an opinion piece, and he said he hopes, and I'm going to quote, that, quote, I hope the Supreme Court will intervene whenever the nation's conscience and laws need a jolt in a progressive direction. That's policy making. Do you agree with that statement?
Do I agree with the statement that that's policy making, or
No, did you
I'm sorry,
agree with what the chief said?
Senator? That's a political statement made by someone in the executive branch.
Okay.
I'm
not going to push it on that. I get it. It's not a good time to make the chief of staff mad, is it? Well, I hope you'll keep this in mind, Judge, if you're confirmed. I mean, this is what judicial restraint is all about. And I think part of the division in our country, America's a big, wide open, diverse, sometimes dysfunctional, but sometimes imperfect, but basically good country. But we have different values. That's part of our diversity. And I think our country works because of our system of federalism. The values in Louisiana may be different from the values in Maine. And if you don't like what's going on in Maine and you like what's going on in Louisiana, you can move. But as our federal government has gotten bigger and bigger and bigger and bigger, what is developed, at least here in Washington, is this managerial elite. And when I say the managerial elite, I mean the entrenched politicians. I guess I shouldn't say entrenched because that's pejorative, but we do have a lot of politicians that have been here a long time. They're members of the media. that are part of the managerial elite. They're members of the administrative state. They're academics that are part of it. There are a lot of corporate phonies that are part of it. And many people in this cabal think they are smarter and more virtuous than the American people. And that they ought to set forth how people should live their lives. People should shut up and just do what they're told. And if they behave, maybe the managerial elite will let them eat meat occasionally. And I think that's part of the division in our country. And I think to some extent, the Supreme Court, I don't want to say contributes to it, but it needs to be mindful of this. I'll give you another example. And this case bothers me. I want you to explain it. I think Lindsay talked to you about it, but I don't know that, I want to hear you explain it. It's Make the Road New York versus McClellan. You remember that one?
I do.
Yeah. Here's the way I read it. Congress, we, in a rare moment of consensus, gave DHS the sole and unreviewable, those are not my words, they're in the statute, the sole and unreviewable right to determine when illegal immigrants should be removed on an expedited basis. The Department of Health of Homeland Security, taking this statute, decided to use its sole and unreviewable authority or discretion to state that we're going to have expedited removal of all illegal immigrants who've been in the U.S. less than 2 years. And you said no. And not only that, but you issued a universal injunction. And I don't understand why. You talked about judicial activism, and I don't see how clearer Congress could have been. Now, the D.C. Circuit reversed you, but I want to hear your reasons for issuing that nationwide injunction.
Thank you, Senator, for allowing me to address that decision in that case. The statute at issue gave discretion to DHS to determine the amount of time that a person needed to have been in the country between 0 and 24 months in order to be subject to expedited removal, as opposed to the normal removal process in the immigration system. The statute said that DHS had sole discretion, meaning no, I interpreted, meaning no other agency was to have the authority to make that determination. And the statute said that DHS's determination in that regard was unreviewable, meaning it was final. Once, this is how I'm interpreting, meaning that once the decision was made, it was over. Nobody else gets to review. The court doesn't get to say, no, you're wrong if you pick 12 months, for example, or 16 months or 24 months, as they did in this case. The statute did not speak to whether Congress intended, with that grant of very broad discretion, to exclude another statute that Congress has passed that directs agencies, when Congress gives them discretion, the other statute, the APA, directs agencies as to how they go about making decisions that Congress has given them the authority to make. The APA is a procedural statute. It says to agencies, when Congress gives you discretion to make a determination, you have to do so in a way that's not arbitrary and capricious. You have to use your expertise.
Right.
In certain kinds of decisions, you have to use notice and comment in order to get information. It's procedural. The claim that was being made in this case, as I read it and understood it, was not that the agency couldn't pick 24 months. Because obviously, Congress had said in the statute, you can pick between 0 and 24 months. The claim that was being made is that the agency picked 24 months arbitrarily in violation of Congress's direction about how you go about
The
exercise.
APA was violated?
Yes, the claim was an APA violation. So no one was saying that the statute was violated in the sense that the agency did something that it couldn't have done per the statute, picking 24 months. They said the APA was violated because, this is the claim that they were making,
Sure.
because the agency did no analysis, the agency did no expertise, the agency did not evaluate, okay, if you've been here 6 months, these are the kinds of ties that you have. If you've been here 18
I got it.
months, right?
Got it.
The agency didn't do anything. Essentially, according to the claimants, the agency heard the president say, we're going to now do 24 months when everybody else, all of the other administrations
I
up
got
to
it.
this
I'm
point.
rushing you because I've only got 2.
Yes, I'm sorry. All right.
What I hear you saying is, tell me if I'm wrong.
Yes.
They didn't follow the APA, in your opinion, which you have to do even though Congress passed the statute? Is that-
Well, no, because 2 things. One is the APA under DC, longstanding DC Circuit case law is presumptively applicable to every situation in which an agency is exercising its discretion. So that's the first thing. It's always there as a background rule. So the DC Circuit has said Congress has to be pretty clear when it decides to exclude the APA, when it's saying, I'm giving you discretion, but you can do this arbitrarily, you can do it however you want. And in other places in the immigration statute that sets up expedited removal, Congress says, we are excluding the APA. We're telling you that with respect to this kind of discretion, the APA doesn't apply.
Okay.
So here I had these 2 statutes, and there are canons of statutory interpretation that says that you should try to give effect to all of the will of Congress. You should try to read statutes so that they go together in a way if you have these 2 directives. And there's also DC Circuit case law.
Judge, I got to stop you
All right.
because I got it.
And let me just say, I agree that the DC Circuit reversed me. They disagreed with my interpretation, and that's the way that our system works.
Let me ask this last question. This is a question about based on your experience. Can we agree that if, I want to emphasize if, cocaine is cocaine, that crack cocaine is equal in its danger to powdered cocaine? You with me?
I think so.
One is not more dangerous than the other. If that's true, then the sentencing rules ought to be the same. Okay?
It's a policy matter for Congress. You could make them differently if you
Right.
wanted to.
This is what I want to ask you.
Yeah.
Based on your experience, you've been on the bench a decade.
Yes.
Is crack cocaine more dangerous than powdered or less or the same?
Senator, that's a policy determination. That's what policymakers do. They look at the evidence related to these things and they decide what's more
But
dangerous.
what have you seen?
What should, I have seen evidence through the Sentencing Commission that the 2 compositions are chemically similar, so similar as to be indistinguishable. And the commission for very many years, as a policymaking body, indicated its view that they should be equivalent and lobbied Congress concerning that. And Congress made a determination about, in the policy realm, making it 18-1 instead of 100-1, which is what it had previously been.
Okay. Thanks, Mr. Chairman.
Thank you, Senator Kennedy. And now Senator Padilla.
Mr. Chairman, before I begin, I know you're being very mindful of the clock. So I just want to say I have 2 initial, more substantive questions, and then I think 2 very brief questions, but are very important. So I'll get right to it. Judge Jackson, I am so glad that you take some pride in sharing your family's story, as you should. I know I take pride in sharing mine. My colleagues have heard it, but I never get tired of reminding folks that I am the proud son of immigrants. My parents came to the United States from Mexico decades ago, and through their hard work and determination, they raised three of us. My sister, my brother, and I, we all attended and graduated from college, and we've all found successful careers in public service. Now, it's a story that is shared by hardworking immigrant families across the country. And over the course of generations, families who work diligently each day to create a better life and to contribute to the country. Whether it's as farm workers, short order cooks, celebrity chefs, software engineers, or tech CEOs, as school custodians, teachers, principals, whether they're documented or undocumented, people who migrate to this country seeking asylum, seeking refuge, or a shot at the American dream, all deserve to be treated with dignity and humanity. Now, unfortunately, our laws and our courts don't always do that. Beyond our often cruel and counterproductive choices that we've made over the years when it comes to immigration policy, the language that we use to speak about immigrants can often have dehumanizing effects. For example, in the Immigration and Nationality Act, it's replete with references to quote unquote aliens. And court opinions written by federal judges across the country can be found referring to undocumented persons as, quote, illegal aliens. Now, I know NASA has put a man on the moon, and there are billionaires increasingly exploring space. But let's be clear, no person is an alien, and no human being can be illegal. So with that context, I read your immigration-related decisions on the district court with great interest. Now, beyond the substance of your opinions, what stood out to me is that you seem to have tried to avoid making the same choice as many of your predecessors and many of your colleagues. When not quoting statutes or precedent, your opinions appear not to refer to immigrants as alien or illegal. Instead, use terms such as undocumented and non-citizen. I hope that was a conscious choice. The language we use and the language our courts use to describe people, whether immigrants, the formerly incarcerated, individuals who identify as LGBTQ, or other historically marginalized people, really matters a great deal. Our language matters. It's exactly for that reason that 6 years ago, Congress passed a bill to remove derogatory and offensive references to Black Americans, Asian Americans, and Native Americans from the US Code. And it's why last year President Biden ordered the Customs and Border Protection Agency and ICE to stop referring to migrants as illegal immigrants. With all that said, Judge Jackson, do you agree that the language we use to describe one another and the language used by the bench matters?
Thank you, Senator. As I mentioned earlier in this hearing, judges are the only branch of government who are required to write our opinions, to explain our decisions. And I have long believed in that capacity, that our clarity and language matters. We're explaining the law to people, and people read and understand what the law is, what the rule of law is in this country through the opinions of judges. So they do matter, language.
Thank you. Now I want to discuss with you an issue of law and technology, an issue previously raised by Senator Ossoff earlier today, and I'm excited to talk to you about this topic. Just as an aside, any day that an MIT engineer gets to question a Harvard lawyer, it's a good day. So thank you for indulging. But as you know, the Supreme Court only hears a tiny fraction of all federal appeals. That means that the cases that get to the Supreme Court are typically either new questions of law or very difficult questions of law. And I think the intersection of law and technology is one where many cases are both new and difficult. Over the course of human history, innovation has constantly disrupted our culture and our norms. And for the most part, with good intentions, but societal benefits have not always been the result of innovation. Innovations have challenged us to respond with new means of safeguarding basic rights, whether in the context of privacy, security, competition, employment, just to name a few. And I appreciate that the speed of innovation will always challenge our ability to keep the law up to date with new technologies and their impact. I've grappled with this question as a city council member, as a state senator, as a secretary of state, and now as a United States senator. But clearly, it's also a challenge for the courts, which often have to decide cases during that period between technological progress and the enactment of new laws that seek to account for that progress. Now, new technology alone has given rise to a number of fundamental questions of law, as you mentioned yesterday and earlier, including how the Fourth Amendment applies to new contexts that no founder could have ever contemplated. And likewise, the court has to grapple with questions like how copyright law applies to computer code. And in the coming years, new technologies will present new questions, not just in the context of the Fourth Amendment, but in areas of communications, energy, transportation, healthcare, and many others. So if you can take just a minute, Judge, to discuss the challenges that courts at every level face in addressing cases involving new and emerging technologies, and how you, as a Supreme Court justice, would begin to prepare for these types of cases.
Thank you, Senator. The court does get cases that involve disputes that touch on technological innovation, whether it is something like copyright kind of case, or a patent kind of case, or the Fourth Amendment search and seizure. New technologies do intersect with what the law says in the Constitution and in statutes. And at least as far as statutes are concerned, it's certainly much easier for judges who are doing their duty to interpret the law if Congress makes changes that update the statutes to track the modern innovations. What happens with constitutional interpretation is similar to what I described earlier about cases in which the court analogizes back to the time of the founding concerning the principles in something like search and seizure. What qualified as a search that violated the Constitution when those words were written, and then determines whether that same kind of violation is at issue with respect to the top technology today. And the court has done that with respect to searches regarding cell phones, police access to GPS data, tracking technology that is put on vehicles, because these disputes do come up. And so, so I'll take this opportunity to encourage Congress to help us by ensuring that new technologies are addressed in statutes that we interpret.
You're absolutely right. Both judges and members of Congress are never done doing more homework and learning, hopefully. Judge, on Monday, which at this point feels like so long ago, I suggested in my opening statement that by the end of these hearings, America would know just how qualified you are to serve on the Supreme Court. And over the course of this hearing, I think the American people have seen that and have gotten to know you as a person. They have heard your family's journey and everything that your nomination represents. Now, I also said on Monday that your qualifications bear repeating over and over again. And so, Judge, with your help, I'd like to remind the committee and the American people once again, just some of your incredible credentials. Yes or no? After law school, did you serve as a law clerk for a district court judge, a court of appeals judge, and a Supreme Court justice?
I did, Senator.
Yes or no? Did you practice law for more than 10 years before becoming a judge?
Yes, Senator.
And did that include time in private practice and time as a federal public defender?
It did.
How many years have you served as a federal district court judge?
I served as a federal district court judge for, I believe, 8.5 years.
And circuit since then?
Circuit since last June.
And as a district court judge, approximately how many opinions did you write? I think we've covered this before.
As a district court judge, I believe I wrote somewhere in the neighborhood of 560.
With a very low rate of having been reversed, if I've done my homework correctly. Look, I can go on, and don't worry, Mr. Chairman, I won't. But Judge Jackson, for 2 days, here's what I've seen. I've seen a number of my colleagues trying to engage with you in good faith on questions about the law, and you've answered them fully, fairly, and thoughtfully in every instance. You've shown yourself to have the keen intellect and legal acumen to serve on the Supreme Court. Now, you've also sat here and politely listened as some of my colleagues have attempted to disparage your judgment and character based on allegations that even, as Senator Booker pointed out, conservative commentators have called meritless to the point of demagoguery. And through that, you've shown clearly that you have the temperament to serve on the Supreme Court. Now, this confirmation hearing has been a reminder, and in some ways, a new Exhibit A, that for people of color, particularly those who have the audacity to try to be the first, often have to work twice as hard to get half the respect. Judge Jackson, I offer that with your talent and exemplary qualifications on full display, if my colleagues truly believe in maintaining the legitimacy of the Supreme Court, if they really care about Americans' faith in the judicial system, they will see that even if they may disagree with you on a particular area of the law, that you're exactly the type of judge that should serve on the Supreme Court. You're exactly the type of judge that should receive bipartisan support, not just from this committee, but from the full Senate. And if any senator doesn't, then I hope they'll think long and hard about what it says to the country about the politicization of the Supreme Court. That if someone is eminently qualified as Judge Jackson in all the ways that we've been discussing, cannot receive bipartisan support. Judge, and there's just a couple minutes left, and I'd like to ask you just one last question. Last Friday, in my preparation for these hearings, I took the opportunity to spend some time with a group of students at South San Francisco High School. I went there to speak with them about this historic Supreme Court nomination and to speak with them about you. We had a great conversation about how the court's decisions affect the everyday lives of Americans and about the past and the future of the Supreme Court. But as I was speaking with the students, I couldn't help but be reminded of my own high school experience when one of my teachers discouraged me from applying to MIT because they didn't want me to be disappointed. I turned that discouragement into motivation. Judge Jackson, I know that you too have been doubted on your way to the seat that you find yourself in today. Even over the last 3 days of this hearing, your experience and qualifications have been called into question by some, despite your clear, lengthy record of talent, achievement, and accomplishment. So I want to end my time today by asking you this question. On behalf of the young people I visited with last Friday in South San Francisco, and for the many others across the country who are watching this confirmation hearing today, what would you say, Judge Jackson, to all those young Americans, the most diverse generation in our nation's history? What do you say to some of them who may doubt that they can one day achieve the same great heights that you have?
Thank you, Senator. That was very moving. And I appreciate the opportunity to speak to young people. I appreciate it very much. I do it a lot for the reasons that you have articulated. I hope to inspire people to try to follow this path because I love this country, because I love the law, because I think it is important that we all invest in our future. And the young people are the future. And so I want them to know that they can do and be anything. And I'll just say that I will tell them what an anonymous person said to me once. I was walking through Harvard Yard my freshman year. As I mentioned, I went to public school, and I didn't know anything about Harvard until my debate coach took me there to enter a speech competition, and I thought, this is a great university. It was basically one of the only ones I'd seen, and I said, maybe I'll apply when I'm a senior. But I get there, and whoa, so different. I'm from Miami, Florida. Boston is very cold. It was rough. It was different from anything I'd known. There were lots of students there who were prep school kids like my husband, who knew all about Harvard, and that was not me. And I think the first semester I was really homesick. I was really questioning, do I belong here? Can I make it in this environment? And I was walking through the yard in the evening, and a Black woman I did not know was passing me on the sidewalk. And she looked at me, and I guess she knew how I was feeling. And she leaned over as we crossed and said, persevere. I would tell them to persevere.
Thank you, Judge Jackson. You don't have to hope. I'll tell you right now, you do inspire. You are an inspiration.
Thank
And I will associate myself with the closing words of my colleague and my brother, Senator Booker, that I too refuse to let anyone steal my joy. Thank you, Mr. Chair.
Thank you, Senator Padilla. Senator Tillis.
Thank you, Mr. Chair. Judge Jackson, as Senator Booker was providing his closing comments, I could only think, and they were very powerful, that if you liked his, how much you're going to like mine on the subject of intellectual property. But before I do that, I know you've been spending a lot of time here. Do you have much experience in matters of copyright protection, patent protection?
Senator, I mentioned earlier that I did a trademark case.
Yeah.
Not
By
that.
the way, I looked up the menu. It looks
Did
like
you?
a really good menu.
I think it's a good restaurant. They had a lot of evidence to that effect.
I haven't done a lot of food or restaurant trademark work, but when I came to Judiciary, fortunately, the former chair and the current chair indulged us in reinstituting the Intellectual Property Subcommittee. And I love that committee because you really have to work hard to be partisan in it. And in fact, it's not partisan. I worked very well with, as the chair, with Senator Coons, and done very well with Senator Leahy and Senator Rono, and working together on things that I think are really important. Because I think one of the things that make our country great is the founding fathers got it right on understanding the value of intellectual property and how it could catapult us into the innovation powerhouse that we are today. So I may ask you a few questions about it, but I'm not going to dig too deeply. I do want to go back to maybe getting a suggestion from you. I thought, I told you, I don't even pretend to be an attorney, but I am about 30 years into technology. As a matter of fact, I spent 2 years in Boston at Wang Laboratories, and it was no coincidence, having been born and raised in Florida, that I moved one September because I couldn't bear another winter. But I've been in the technical field. I was working on IP, or Internet Protocol, before anybody knew what Internet Protocol was back in the early 90s. And I do think that we should go away and understand the threat. If you've seen the multiple of illicit activities, and for the purposes of this discussion, child pornography now, imagine what it's going to be like 5 years from now. I was talking with someone in the hallway. They're taking a playbook from drug kingpins, the creators and the aggregators and the distributors are using technology, I think in some cases, to reach out to people and incent them to go to these websites, to infect their computers, to download thousands potentially from a single click. I think that we have to examine these criminal enterprises and put law enforcement resources into cutting the heads off of these people, figuratively speaking. And one of the ways you do that is to provide, I think, more ways to go about prosecute, more technology that we need to cut down the supply. But we still have to deal with the demand. And that's another area where these criminal organizations and others are taking advantage. And, you know, today, if you think about technology 10 years ago, it was a little odd, at least 15 years ago, to see a child. I've got two granddaughters. One is 4 years old, one is 2 years old. They're technologically savvy. As a matter of fact, I love talking to them on the phone, but even my 2-year-old knows how to deal with the filters to make me look like I've got rabbit ears and everything. They're technologically savvy. There's a real danger there that these horrible people, and I genuinely believe that you think
they're horrible people, are going, they're going to infect and destroy a lot of lives. And so I don't know, is it with the Sentencing Commission? How would you, and incidentally, this is a toxic subject in Congress, because if you start talking about better understanding this, most people are going to run away from it. But we do it at the expense of destroying a lot of victims' lives. So I don't, unless you have ideas off the top of your head, I'm trying to get an idea of how we can make people understand. Maybe we could even have a discussion to say that the penalties today are the floor to begin the discussion, just to simply eliminate people from making this so toxic that we don't better understand it and get ahead of it. But how can we even start having an intelligent discussion and a productive discussion where Congress is clearly going to need to act to do what I think everybody in this room wants to do, is just erase it from the planet of the earth, or at least make a lot of progress? Because quite honestly, it has exponentially grown, and there are exponentially more victims today than there were even 10 years ago. Any ideas?
Thank you, Senator. I actually don't. I haven't been working on or looking at or dealing with sentencing policy for a long time now. In my work as a judge, we're looking at individual cases, not systems or crime organizations and policies related to them.
Yeah. Well, I think it's something that we should take seriously. And after we cool the temperatures and have people have legitimate concerns about some of the rulings, I think that we have to clear up some of the complexity and recognize that Congress is a part of the solution. Okay, now on the weighty subject of intellectual property, are you familiar with copyright preemption under Section 301A?
No, I haven't worked with that.
Okay. I wouldn't have expected you to necessarily, but, and I won't get into patent questions. We've got a lot of work that I think ultimately is going to require us getting rid of the shambles of jurisprudence that we have. It's a very complicated field. We've got a lot of mixed signals and current jurisprudence, and my committee's working on that. So it may be something that ultimately works its way up to you all if you're confirmed. But I'm not going to take a lot of time, particularly because the hour is late and I intend to yield back some of my time. I do want to go back because I felt like this morning when I went through some of my comments, I mentioned law enforcement. I talked about a couple of your decisions that gave me pause, mainly, excuse me, because, law enforcement's under attack. Law enforcement needs to be held to a high standard. I've been involved in this for nearly 22 years, making sure that when I was the town councilman, that we did something audacious and spend a lot of money in getting our law enforcement officers in a small town of only 20,000 people, CALEA certified. That's a national certification to make sure that they understand how to de-escalate, get engaged in the community, and reduce crime. And it worked. But now there are some people that think it's fashionable to attack the police and to defund the police. And quite honestly, there's increasing data that suggests the communities that are loudest about that are becoming the least safe. So I want to ask, you mentioned several times, I think yesterday and more today, about your methodology. So is the United States versus Jenkins fresh in your mind, or roughly fresh in your mind? Criminal pleaded guilty to assaulting a law officer. It was his third conviction. And assaulting a law enforcement officer. The government recommended 30 months. The defense recommended 21 months, and you decided to go with an 18-month sentence. So I was trying to, do you recall?
I don't recall. I would want to look at the records and see the probation office's recommendation as well.
Okay. And that again is something I wouldn't have access to. So I'm just trying to figure out what the mitigating circumstances were, and there were other ones, and unless you immediately recall it, I'm not going to ask you to go into details. The other one was United States versus Weeks. Similar situation. There was a 24-month request from the government. for the conviction on assaulting an officer, and you gave him 12 months. And are you from, does that ring a bell, United States versus Weeks?
I think Weeks had a number of different appearances and there were different aspects to his case, but I'd have to look at the whole file to recall.
That, I just feel like the, again, because I know that you've rendered some 100 sentences over a period of time, I wouldn't expect you, but it is an area that we'll submit it as a question for the record so that maybe you can refresh your memory and try to get back on that, because it's something that I, for one, think that we need to place a priority on. We've got so many law enforcement agencies across the country now, excuse me, that we're having a hard time recruiting people and having a hard time retaining people. A lot of people are retiring. And, you know, I know not every police officer is an angel. I was talking with somebody in my office who was talking about her brother. She had a lot of confidence in him. She was here to talk to me about police reforms. And I actually believe that the vast majority of police officers, like your brother and your family,